It's Friday Night Live. It's so good to see you. We have so much to talk about. I'm going to turn the lights to red when I roll the intro because there is, you know what, the F afoot. Some of the stuff we're covering tonight is just mind-boggling to me, and I am a little late because I was running down a rabbit hole and I can't stop. So I think this week's episode of the podcast is going to cover the Murdaugh case because I don't think we're going to get to everything tonight because there are a lot of new documents in the H3H3 case. And then there's a lawyer who filed a document in federal court with a picture of his butt, and I just cannot. Like, a lot's happening this week. Adele has a new song. I'm in my feelings. Like, what is even happening tonight? I brought whiskey and my ice is starting to melt. It's just time. Let me know where you're coming in from, Law Nerds. We need to have a chat. Y'all, I don't even know what's happening with these lawyers out in these streets, wild and out. Like, every now and then, I'm going to roll the intro in a second. I super promise. Every now and then, I'm like, I get a comment like, you're not a real lawyer. I'm like, look, man, I am a real lawyer, but I'm also a legal commentator. But also, lawyers are allowed to have personalities. But what you're not going to do is come all up into federal court and file a picture of your butt. I'm going to take a poll to see if you guys want to see the picture or if we gloss over it. It's not super NSFW. It's not a Trisha Paytas butt pic. So I'm going to leave it at that. Let me know where you're coming in from. Replay crew, love you. Timestamps are down below. We've got court of public opinion at the end of the stream. We've got a lot to do. Let's go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. All right, we're going to go ahead and end the poll we've got up there. It's so good to see you all coming in. And if you are a new law nerd, if this is your first live, go ahead and put the 1 in the chat. I'm still trying to make this go red because I have there are Wi-Fi things that have to happen. Like, the tech in here is more complex than I think it needs to be. Well, no, it's probably just as complex as it needs to be because it needs to be complex, but it's all right. We have Wi-Fi enabled lights on 2 different Wi-Fis. It's a whole thing. Zakun said, as usual, love having you with me for my 2 a.m. commute to work. I am so sorry that you have a 2 a.m. commute to work, but I am so glad it coincides with all of the nonsense that's popping off in the legal world today. We got to go to DEF CON Red this evening. We're red. Trisha Lynn, you make an excellent point. Negative, but we'll have to take a poll. I asked you guys if you had been following the Alex Murdaugh case, and it was a no 77%, yes 22%. Y'all are going to be shook. This is the craziest. Like, everyone from South Carolina is like, bitch, we know, but the rest of you, prepare to be shook. It is one of the craziest things. It's like Girardi plus a murderous conspiracy legitimately, and multiple people have actually been killed. It's insanity. So we're going to go through all of it. I love seeing you guys coming in. Hello. Lots and lots of new law nerds. Thank you for joining us tonight. I always love seeing you guys find the stream and getting to join us live for the first time, because getting to chat with the chat is one of the most fun things. It is. I love it when I premiere stuff. I love chatting with the chat. It's so good. Mother of 4 cats said my HOA is fighting amongst themselves, and I'm over here like, nope, me. When my HOA does the same thing. I'm the one at the HOA. He's like, there's a process, people. There is a process. These are the rules. We are following the process. I am either the person you want on your HOA or not the person you want on your HOA, depending on what you are trying to accomplish. So we have a weekly roundup. Then we are getting into Alex Murdaugh. So Let's just go ahead. Tech's going to put up a poll. You guys let me know. Do you want to see the picture that's filed in court? It is not appealing, but it's not NSFW per se. And I will let you know when it is coming up because we will do that. So let's get into a weekly roundup. Ronnie A, thank you. Happy Friday to you too, because it's time for a weekly roundup. It Weekly roundup. So first of all, Adele released a new song. I know this isn't legally related at all. It's like Emily related. I live. I just live. I just live. It's glorious. I love Adele. I was just so happy. Like it was a bright spot this week. This week has been wild. I feel like I say that. Do I say that every week? Ugh. Every week, I'm like, you guys, so much is I've lived 10 years. Like I've lived 10 years. Look, Zach Peter has got me ordering shit on the internet because I need all the face rollers. I have like 17,000 different ones. And now I have this big bad boy. That's how many weeks I've lived this week that we need to take the like face rollering to the next level. It's just, it needs to, it needs to happen. So Adele released new music. I thought it was amazing. We had an incredible members only live stream last night. We talked literally about everything from burnout to Britney Spears and all of my thoughts uh, about filings, about recent filings, about vid, summit. I shared some photos that I haven't shared on social yet from vid summits from some of the YouTubers I got to hang out and chat with, all the things that happened. My parents left this week. They were here. It's a whole thing. House guests are I made my mom watch Housewives twice. I feel like it's going to be held against me for the rest of my life because she was like, I don't understand why this is television. I'm like, go back to your cozy mysteries and your Brit shows. All my mom wants to watch is like Call the Midwife. So the Housewives are definitely not her speed. That is my little weekly roundup. Also in the news, Robert Durst was sentenced. He was convicted last month. We talked a bit about it. If you aren't familiar with the Robert Durst, not Fred Durst, Robert Durst, like Robert Durst. If you are not familiar with Robert Durst, he is an old real estate tycoon. He was believed to have murdered his wife in 1982. She went missing. His best friend provided an alibi. It is alleged his best friend provided an alibi. His best friend being Susan Berman. Susan Berman was then killed in 2005. Deputy District Attorney John Lewin prosecuted Robert Durst for that killing of Susan Berman, and he was convicted. He was sentenced to life in prison without the possibility of parole. However, he is fairly old and a bit decrepit, so I don't know how long life in prison without the possibility of parole will be, but he has been sentenced. The DA really put forth the theory of the case that the reason that the best friend was killed is because they had reopened an investigation into the disappearance of Durst's wife and that he had killed the friend who had provided a false alibi to silence her. And it was on a HBO special, and the audio from the HBO special was used in the trial. When he was asked about the killings, he went off screen and was not being filmed, but still was live mic'd. And he said, well, what did I do? I killed them all. And that was, that audio was used at the trial. I watched his, part of his cross-examination from John Lewin, and John Lewin did a great job, I think, cross-examining him and really bringing out flares of anger to show the jury who this man is. And I'm just going to, let me pull up the, Emily, maybe you pull up the article and show what he looked like to this jury, because how juries perceive people and how DAs perceive people can be different. But then when they're on the stand, mind you, Robert Durst, as a defendant in this case, was on the stand for 15 days. Now, these are slightly shorter days because of COVID, but still 15 days. So there was a lot of cross-examination. There was back and forth with the judge. The judge in this case is a great judge who I had the pleasure of working, before as a DA, and I always thought he was great. So I was happy to see, him taking the reins of this trial, because, it's always fun to see people, on TV and go, hey, Judge Wyndham, good job. I like you. Oh, that's not helpful. Nope. Let's try that one more time because we're professionals here, people. We are professionals. We are professionals. There we go. So this is what this is how he was presenting in court. He also had a plastic face mask on some of the times, but when he was cross-examined about the killings, he was asked, did you do this? And they're like, he answered no. And it's like, but if you did, would you lie about it? And he's like, yes, absolutely. And I think for a jury, that is one of those moments when you're like, okay, fair. There was also another killing that he is connected to that he was acquitted of because he provided a self-defense defense, and that was believed by a jury. And so he was acquitted. But this was not the best friend, Susan, was not the only person that Robert Durst has killed. It seems that he has killed 3 individuals. So that is what that is. Yeah. So life in prison without the possibility of parole. We'll see. We'll see how long that is. Again, he's old. We know he's old. Let's get to this Upper Deck case. Not Upper Deckers, Upper Deck. This is a Lawyers in the News. A lot of you tagged me in this on Twitter. Law Nerds, let me tell you how much I appreciate you when you tag me on Twitter and stuff that I haven't seen. I don't see everything on social. There are lots of times during the day when I am not on social. So when it's like, Emily, I don't know if you've seen this. Probably not. And yes, please and thank you. So I am at the Emily D. Baker. I appreciate you so much. And so a number of you tagged me in this story and I was like, wait, I'm sorry. What? I have questions. Is exactly how I came about it. So let me show you the original tweets. And then I went on a deep dive and pulled a whole bunch of court documents because I needed to know all of the surrounding circumstances. Like, it wasn't just enough for me to be like, wait, what? So this is the tweet that a few of you tagged me in. Thank you to Lord of Nurgle. Nurgle. We're going with Nurgle. Thank you for tagging me and asking which color this is. I've gone to red. I've read the court documents. We're now at red. I've never filed a picture of my ass in federal court. Apparently, that's a thing people do. Page 25 explanation. So we're going to go through a bit of this filing. I'm going to give you a little bit of a history of this case. I totally forgot to swoop. I should do that. Upper Deck. Upper Deck sues a dude for trademark infringement. This case is so ridiculous. So, dude, Miguel Flores is selling Upper Deck cards, baseball, basketball, collectible cards on eBay. It seems to be not a ton of them. We're just going to go document by document. So this is not going to be a super deep dive into the legal. It's going to be the lawyers are fighting. Like, mom, make the lawyers stop fighting because the lawyers are fighting. Like, make the lawyers stop fighting because they just go in. So the First Amendment complaint is for false affiliation, endorsement, false advertising, and unfair competition for the selling of the cards on the eBays, trademark dilution, registered trademark infringement, right of publicity, commercial misappropriation, violation of California unfair competition law, violation of California common law unfair competition, unjust enrichment / quasi-contract. The parties, Upper Deck. Upper Deck is the leading manufacturer of, among other products, trading cards, holding exclusive licensing agreements with various professional athletes, maintaining trademarks, logos, designs, and word marks. On information and belief, Miguel Flores is an individual who uses an eBay account under the name of MigFlow 3000, 3800. The true names, they go on. They're talking about these being the Upper Deck logos. I'm sure most of you are familiar with them, at least in the US. Are Upper Deck trading cards of things outside the US? All y'all, our lovely international law nerd crew. Is this a thing elsewhere? Let us know, because we now know that we're knocking things over. Candy corn is not, but is this? So these are examples of defendants' products. The cards for sale featuring Upper Deck trademarks and Jordan's image, likeness, and or autograph. These were apparently listed as reprints, facsimile reprint, but they are saying that they are not authorized reprints, that these are fakes, and the using of the reprinting the Upper Deck logo, much like recopying a movie and selling it, is counterfeiting. So they're saying, no, even though it says they're reprints, they're counterfeits, not reprints, and that's a problem. Hi from Ireland. This is what I needed after a Zoom meeting I had today. Thank God I have never seen or talked to that person again. Well, good. We're good. You guys are like, not a thing, not a thing. Okay, they look counterfeit. Not a thing in Finland, not a thing, not a thing, not a thing. Thank you guys. We appreciate the not a thing. So this is what they're alleging, essentially, that the cards are, fakes, or that the cards are fraudulent, and this is a fraudulent reproduction of the logo. That's the heart of the lawsuit. GMA Grading suspends grading and encapsulation for reprints and custom cards as a part of our ongoing effort to protect collectors in the marketplace and to preserve the value for our customers. GMA Grading has decided to suspend grading and encapsulation for custom trading cards and reprints, as we are unable to guarantee provenance for many of these types of alternative trading cards because they may appear to use non-licensed images, logos, likenesses, etc., etc. But they had been grading, meaning the company that looks at something and authenticates it. Like, there are companies that authenticate purses for resale. I am much more familiar with trademarks in the luxury purse versus counterfeit market than I am with trading cards. So forgive the analogy, but there are companies you can send a purse out to have it authenticated. So this is indicating that this was a company that was going through and grading cards, but they are not doing reprint cards. I see you guys asking where Fred is. He is right. He is on the ottoman. He has claimed the ottoman for himself. So they are both hiding back there. So let's see. We're going to get back through the complaint. We talked about the causes of action. This isn't really the issue. The issue is that the lawyers started getting wild. So this first amended complaint was filed on, let's get a timeline, filed on June 29th, 2021. Then there was a default entered in the case, meaning, hey, you've been served, you didn't show up, so you lose. Here's your default. Happy default to you. Plaintiff wins, you lose. Goodbye. So the default was entered on August 10th, 2021. It appears from the record in the above entitled action that the summons issue on the amended complaint filed on June 29th has been served upon each of the defendants, and it appears from the affidavit of counsel for plaintiff and the records herein that each of the defendants have failed to plead or otherwise defend the action as required by the summons. So the case gets filed. Defendants don't answer. A default is issued. The same day the default is issued, the defendants file a motion to set aside the default, saying, no. Plaintiff told us we had an additional 30 days, so we are not in default. We are relying on our conversation with counsel, and this is where things start to go. This is where things start to go south, because it is in it's in the reply to this motion that we get into all of the wildness with photos of the butt, but we need the history as to why this got filed. So this attorney says, no, I had been given 30 days. We had all kinds of stuff going on. And then the defense attorney, or the defendant's attorney, says that he had quite a lot go on in his personal life, and this is part of why he had the extension from plaintiff's counsel, including the passing of his mother, the funeral for his mother, family and personal issues, surgery with a young child, the press of other case deadlines, so other shit, and a constant stream of personal health issues that have warranted doctor's appointments and medical care and time for recovery since July. So, hey, Your Honor, we're not supposed to have a default. They gave us time. Look, here's my declaration. All of this shit happened, not just in my life, but I also thought we had an extension. Here's our correspondence from May 26th. 30-day extension to respond to complaint on the condition that you agree to accept service on behalf of your client in this matter so that plaintiff is not prejudiced by defendant's delay in filing a responsive pleading. And that's really saying lawyer to lawyer, hey, if we don't have to go track down your guy and serve him, if you as the lawyer on this case accept service, then we will give you a 30-day extension. This isn't uncommon that the lawyers will accept service for somebody, and that's what was done here, or at least seemingly done here. The same day, the lawyer confirmed the agreement and said that defendant was the purchaser of a lot of 33 trading cards. Only 4 were upper deck cards. 8 featured the image of Michael Jordan. Among these, my clients has provided me 3 cards that meet the description of those identified in your complaint. At best, your allegation involved the sale of less than 10 trading cards and involved de minimis damages at best! Exclamation point. These reprint cards were purchased by my clients and were sent out for grading. When the cards were returned, he was advised that they are reprints, but that they are not counterfeit. Now, you're going to have to help me. I am not flexible enough to get to the difference between a reprint and a counterfeit. I think they are implying that a reprint is somehow like an authorized card because it's not counterfeit, but it's like reprinted. So we'll see. They go on to say, indeed, Mr. Flores' sale of these handful of cards barely netted enough to cover the cost of grading, packaging, advertising, and shipping the cards. And I simply cannot comprehend why you choose to file this case, let alone persist in your past, present, and ongoing threats to pursue your client's claims herein. I mean, filing the lawsuit's not a threat, it's a promise, and it came to fruition in this case, but okay. Y'all are like, reprints are like editions in books. Reprints are second printings. So reprints would be, thank you all. Reprints like second editions. This is why we have a law nerd chat. Y'all are the best. Thank you, chat. So a second printing. Perfect. That reprints. Thanks, y'all. See, I told you, I'm better with purses. Past, present, ongoing threats to pursue your client's claim. I mean, they filed the lawsuit, they're pursuing it. Please note, dozens, if not hundreds or even thousands of similar and identical cards are presently being offered and sold by many diverse traders. Hey, Upper Deck, why are you picking on my client? With all due respect, fuck off, man. It's like 4 cards. That's essentially what they're saying. I've even attached a few examples of identical cards for sale on eBay. I also sent a formal offer to compromise the matter and advised particularly that, quote, we have no intent to default in this action and thereby demand that in any future filings you advise the court accordingly. Despite my additional detailed follow-up letters, plaintiff's counsel, including June 4th and June 15th, and several telephone messages, they did not acknowledge, reply, or otherwise discuss the matter. And then it goes into the matter of the default. You can already see that these attorneys are salty. They also say there's excusable neglect on my part, some of which is unavoidable. I'm a sole practitioner who has had to lay off most of my staff due to COVID. I initially took on this matter on a highly reduced and practically pro bono fee schedule. Like, bro, I'm not even getting paid. To defend Mr. Flores from the claims that are plainly improper filed in the state of California before a series of extenuating circumstances occurred this summer. To the extent that the response is delinquent, it is caused in part due to the inordinate time it took for me to meet with my client, research the claims, prepare the documents. This doesn't mention any of the life stuff. The need to research and review the various and relatively complex areas included in this litigation, as well as the particular facts I did not expect to occur at the time I agreed to represent the defendant. Bro, that's on you. The case is more complex than I thought. This shit's more work than I thought is not your excuse. Like, all of the other stuff, like, hey, all of this life shit happened is like, this couldn't get done because all of this other stuff happened, makes sense. But like, I took this case, I'm barely getting paid, and it takes way more time than I thought, is not it for me. It's just, that's a no for me. Like, that's a nope. And I am empathetic to this defendant getting sued by a massive company. Yeah, it's a nope for me. All right. So then they say this included 9 days of hospitalization. My mother I don't know why he put his mom's names in quotes, but okay, my mother passing away after dealing with siblings. I gave a eulogy at my mom's funeral. Other than immediate engagements, I did not work during that time. Here we go. During which time I developed a craniofacial infection, as well as an infection on my right buttocks, which has made it difficult to sit and type. In addition, I have been suffering from irritable bowel disease for more than a year, which typically flares up when I am stressed and or do not have a proper diet. Look, you are a lawyer. Your entire life is stressed without a proper diet. I have been there. There is a reason that I consult and commentate because I like living my life and don't want to live it stressed and with IBS. So then we're going to continue. Y'all are like, is all this detail really necessary? No, but yes, because it sets the stage for what comes next. On June 11th, my youngest child underwent surgery, which is tragic and should not, again, the surgery, the family passing, the hospitalization, these are all things that you can tell the court. I don't know if we need all of this details, but we're going to get it. On June 11th, 2021, my youngest child underwent surgery. I hope the youngest child is okay. For nearly a week, my wife was away traveling for my child's care, and I took on several additional duties. Well, yes, when your wife is gone, you have to do other shit. That's how that works. Visited several doctors and fell into a bout of depression. I mean, I have heard, look, all the while I have tried to earn a living. Look, Haley Page, here's the thing. Just spoken as a woman who had 2 high-risk pregnancies, still practiced law well in the midst of 2 high-risk pregnancies, and was like running a household. Look, it's hard out here for a lawyer because you have to like do life shit and work, and it's hard. I get it. This is a whole lot of life shit all at once. Totally get it. This is why I think he should have left out that he took this on reduced fee and that the case took more work than necessary. Because the life circumstance stuff is enough to say, look, this didn't get done in time. That's it. You didn't need to add in the other stuff because the personal life stuff is enough. But also, you don't need to add on like, my wife was gone and then I had to do other shit. Yeah. You have to do life shit. Guess what? Sometimes you have to be in trial and you have to get your kid a Halloween costume to school for a Halloween parade that's always at 10 o'clock in the morning, because who would be in court at 10 o'clock in the morning except, lawyers. But, that's when they do all the things at school. 10 a.m. So don't tell me you had to go get groceries because your wife was out of town. I hope that their child is fine. But also, stop bitching about having to do life shit because your wife was out of town. Because I just cannot. I just cannot. The other stuff, though, I am sure with the health issues and a parent passing and a child having surgery, that's enough. This could have been done better. Maybe run this by someone else in your office before you file it, so you just don't sound like a man who's unaware of the amount of work that your wife actually does. Because that's how it comes across to me. All the while, I've tried to earn a living, meeting with other clients and prospective clients, presently engaged in a number of other pressing legal matters, which have also demanded my time and attention. We get that you're just one person, but you took on this work. And if you took on the work, you have to do the work. I've sincerely tried to reasonably discuss this case with plaintiff's attorneys, but they have failed to respond to most of my overtures, making the somewhat sensitive explanation of my personal family and health issues, warranting a brief delay, and further written meet and confer discussions more difficult, if not impossible. This is where we get to the fuck you to the other counsel. Like, and they won't listen to me. Earlier today, prior to filing this motion to vacate, an attempt to confer with Upper Deck's counsel was made by phone, but Mr. Litney rejected the call. How do you know they weren't just in? How do you know? Objection Facts not in evidence. How do you know that the other attorney rejected the call? Reject. Like, this motion for me would have been much better taken if he had stuck to I had a parent pass, I have had health issues, and I have a child that underwent surgery. Those things alone are enough. That is it. You don't need to say that you are still trying to make a living. You don't need to say that you took this case pro bono. None of it. Those 3 life things are big. You don't need to add in and my wife was out of town and I couldn't function. Just stop. Just stop. The other 3 things are enough. And any other co-counsel should have compassion for those 3 things. When you add in all the other shit, it diminishes the weight of the important shit. And I will say, I don't know if a female attorney would have felt comfortable to file this to the court because of the amount they go above and beyond. That includes, attorneys of color. Like when you feel like you are not, that the court might not always look favor on you and you already have to prove yourself, it might be harder to say, but I'm still out here trying to make a living and it's just me. So there is no need to pad it. The other things are big enough. And I have empathy for losing a parent. I have empathy for the stress of a child having surgery. I have so much empathy for health issues. I've had it too. But this is just, ugh. But remember, he has a booty infection. So he mentions in this motion that he is suffering from a craniofacial infection as well as an infection to his right buttock that flares up, with the IBS. So it is IBS plus an infection plus all the things. So Upper Deck probably has an entire law firm working on this. I am sure that's like, no, bro, what we're not going to do is this. But without getting to, I will get briefly to Upper Deck's response, and then we are going to get to the filing of the booty pictures because he does file a photo of his ass in court. And I feel like that's necessary for our conversation. Like we need that for our conversation. And I've closed the wrong window. Of course, why wouldn't I close the wrong window? Because we're professionals here and I'm all fired up about this. Like I'm all fired up about all of the complaining. I'm fired up by the complaining. Dr. Riley, clearly he felt that somebody demanded pictures and that's why they were included. And as I said, I have empathy for all the life stuff. It's the padding all the other stuff that just put me over the top with it because it was so just, it was just enough. It was enough. All right. But at least this dude, here's the thing. We will give credit where credit is due. Unlike John Pierce, who went into the hospital for a mystery illness, this dude explained himself quickly to the court, quickly to try to fix the motion to dismiss. He didn't have somebody who's not even a lawyer show up and appear for him in court. He didn't pretend that everything was fine. There was at least an effort made. And for that, I appreciate it. So thank you for at least making the effort to explain to the court all of what's going on. So then we get to his reply. I'm not even going to pull up Upper Deck stuff because otherwise we're never going to get through this. We have so much to talk about tonight. We'll get to the communications because these emails are really where the tea is. The attached are communications sent to Mr. Litany. While they are not directly relevant to the issues raised in defendant's motion to set aside the default, they respond to Mr. Litany's inappropriate suggestion in the plaintiff's opposition that somehow by properly resisting unlawful discovery tactics or relying on the federal rules of civil procedure, the defendant is guilty of spoliation, destroying your shit, deleting your shit. Guilty of deleting your shit, concealment, or some other type of inappropriate behavior, and then attaches all of their emails. And their emails are snappy, just snappy. Thus the case you cited confirms my position. As such, I sincerely think you are horribly mistaken in your approach. Try reading the Federal Rules of Civil Procedure. You're wrong. Go read the FRCP. What? This is just ugh. There's more. It just gets better. It just gets better. Hi, Stephen. There is no deadline to comply. Stop the mendacity. Hi, Stephen. I learned that you called our office. Please send your meet and confer correspondence via email, and I will promptly consider it given the imminent deadline to comply with plaintiff's subpoena. Also, while I can appreciate that there is a disagreement between counsel regarding this case, I will have to insist that you refrain from yelling at my staff in the future, particularly as this is not the first time I have been informed of such behavior. Thanks, Ethan. So now we've got the dude with the booty infection yelling at the staff when he tries to call. So this is the dude that said in his motion, Mr. Litany, Ethan, refused my call. No, maybe not. Maybe he didn't, but maybe when you call and scream at his staff, which is implied in this email, they don't want to talk to you and would prefer to handle things by email. We can see why as these email correspondence go on. So, this is Ethan trying to explain his position. The response is anything else to this email that is so long. The response is anything else. Hi, Stephen. Please see further our response to your meet and confer. This is their response to the meet and confer. Like just law, you're wrong. And his response, rather snarkily, is anything else. Hi, Stephen. I apologize. I omitted discussion of one of my preliminary procedural issues you raised. Here it is. Like, oh yes, anything else? Yes, there is. This is more about the meet and confer. Mr. Litany, please refer and respond to the enclosed correspondence. In particular, please advise me immediately when you are able to meet and confer, discuss the motion to quash. As is imminently anticipated, should you fail to withdraw the overbroad, premature, and unreasonable subpoena that you emailed me last evening, I look forward to your prompt and thoughtful response. This relationship is deteriorating in front of our eyes. Dear counsel, please provide evidence which supports your latest baseless and spurious claim that you have, quote, learned your client appears to have destroyed relevant evidence related to this action, including but not limited to social media, Instagram posts, evidencing past advertisement of the counterfeit cards. They're saying you deleted your shit, and he's saying we didn't delete our shit. Once again, you are apparently continuing to harass my client and vexatiously increase the cost of your ill-founded litigation. With the above in mind, I look forward to your prompt reply. So mad, so mad. Stephen and Ethan are not getting on well. Ethan, oh please. Oh please is the response to this email of like, here, this is what spoliation means. This is what we think your client did. They think we have learned, this is what they say, we have learned that your client appears to have destroyed relevant evidence relating to this action, including social media. If your client has separately maintained records of any destroyed evidence, please let us know when those records will be produced. So, hey, we think you deleted your shit. Please let us know. Oh, man. So then, Ethan, oh, please. I would sincerely appreciate if you would refrain from taking every opportunity to misrepresent my prior statements and communications in each of your self-serving correspondence. Well, yes, they're of course they're self-serving. He's counsel for the other side. This is why I love reading this stuff. I hate participating in civil litigation. Oh, please, is not the best way to start an email with opposing counsel. Especially, look, when you're asking opposing counsel for empathy, because these emails are in October, when you're asking opposing counsel for empathy, maybe actually ask for empathy and don't stop going like, oh, please. Okay, look, once we finish this, the photo is the next thing attached. I'm just heads up, just a heads up. We'll get there in a second. We're not going to timestamp it, but we'll get there in a second. My client has always been willing to provide information regarding where he purchased the cards, and they were identified by GMA grading as facsimile or facsimile reprints. I've repeatedly advised you of that. So it's like, stop picking on my client. This is dumb. These aren't counterfeit. These are reprints. Clearly, the other side disagrees. I think when lawyers act this way, it makes it less likely for the other side to back down. Like when you can't find a way for the opposing counsel to sell to their client why it's a good idea to leave, and you have them backed up where you are now locked horns, it makes it really hard to come to a resolution. Versus when you're like, look, my client says this, your client says this. How do we find a resolution? We've already sold the cards. We can't grade them again. Like, what are we going to do? So, and then it seems like out of turn, but he goes on about the Instagram post. We can't see the Instagram post you referred to. Did you screenshot or print it? Well, they're saying it's deleted. So of course not. Perhaps it was one of the other two cards that he took down, blah, 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 blah. And then attaches this. The infected booty is attached. Like, this is in court. What is happening? Also, y'all voted on that. I'm just saying, look, 84% of you wanted to see it. So there we go. These are court documents. YouTube, they're for educational purposes only. This is a court filing. Court filing. It is a court filing of the arse infection. So there you go. So there, that got filed in federal court. Let's get to the supposed explanation for why that photo was attached, because I don't quite understand, but apparently we will learn on page 25. So we are going to page 25. We will learn together. I did not read this whole document. This got previewed. I mean, it's all. He didn't even drape it. He didn't drape it. I'm sorry, Lulu, that you voted no. We're all emotionally damaged. I mean, can he be held in contempt for TMI? I don't know. Yeah, we are going to immediately get demonetized, but it is for educational purposes. Look. All right. Where are we? We are in a letter from Ethan from Upper Deck. Somebody asked, why didn't we put a dime next to it for scale? This is an excellent point. I mean, if you're going to file it in court, you should drape it and maybe put a dime next to it. So, I mean, Kyla said, dude has an abscess on his butt. It's not that unusual. It's not that unusual, but he is making it a very, very big deal. I think the other life things he has going on are a bigger deal, but he's making this a very big deal. Maybe he just wanted to show his ass to co-counsel, to really tell co-counsel how he feels. I mean, but if you're going to put a picture of literally your whole ass into court, do you just groom? I would imagine you can't really go groom with an infection, but like, don't we do something? All right, let's take a look at page 25. Notwithstanding your objection, counsel attaches a photograph of his ass for Mr. Litney. Produce all documents supporting the assertion by Stephen Anderson in his declaration of support of your motion to set aside the default that, other than immediate engagements, I did not work at any time for more than 2 weeks later, during which time I developed the craniofacial infection as well as an infection in my right buttocks, which made it difficult to sit and type in a look. Laptops. It's the lawyer's butt, Zara. It is Stephen, the angry lawyer's butt. And Ethan is responding about it. So, produce all documents supporting the assertions by counsel Stephen Anderson in his declaration in support of their, being them, defendant's motion to set aside the default that, other than immediate engagements, I did not work for any time for more than 2 weeks. for more than 2 weeks later, during which time I developed a craniofacial infection as well as an infection in my right buttocks, which made it difficult to sit and type. I'm sure it did. In addition, I've been suffering from IBS for more than 1 year, which typically flares up when I'm stressed and do not have a proper diet. Docket entry 8-116. Objection. This request seeks the confidential, personal, and medical information of counsel, which defendant has never possessed nor has any interest in. Well, defendant client doesn't possess it, but lawyer does. The request is abusive, irresponsible, what means unresponsible, and seeks information not reasonably related to this action. Well, you're asking for the default to be set aside because of your infected ass. So it's reasonable that they say, tell me more. The request is premature. The request is compound, vague, ambiguous, fails to identify the subject matter with any reasonable particularity. No, it's defined. The request requires a legal conclusion. No. These are just boilerplate. The request is unduly burdensome. The burden or expense of the proposed discovery outweighs its likely benefit. These are just every objection. Notwithstanding said objection, counsel attaches a photograph of his ass for Mr. Litany. Fuck you. But also, here's a picture of my butt. Oh my God. Lawyers, why are they the way that they are? Produce documents evidencing medical consultation for treatment for the craniofacial infection. Like, prove to us that you have this all going on. And they keep objecting. Produce documents evidencing medical consultation for your treatment of IBS. And they objected. So the court's going to get to deal with all of this. And I am now invested. I hope that you are too. I want to know what the court says. Is the court going to admonish defense counsel for including a photo of his ass not under seal? Is the court going to say the photo of the ass was too much? Is the court going to say, you know what, counsel, you asked for proof of the ass infection, but the photo, hold on, I'm not putting this up on the screen. I don't think the photo's timestamped and I don't think there's any metadata. Like, how do you prove that this is not like Google? We could do a reverse Google image search. I'm not going to make y'all sit through that. How do we know that this butt cheek belongs to the attorney? It's not timestamped. It doesn't have any metadata. How do we know? How do we know that this is actually the attorney's ass? How? How do we know? And did he ask somebody at his firm to take the picture of his butt? I hope not. We know James Charles allegedly asked his employees to shave his butt. Oh my God. This is just, oh, it's attached. It's beta stamped in here. I might reverse Google search this to see, because how do we know there's no authentication for it being a picture of his butt? That's what I would say. I would be like, how do I know that's your butt? Also, he could have provided as morbid as it is, a death certificate for his mom. But here's the thing. If this lawyer, Stephen, hadn't come out of the gate guns blazing, saying things like, oh, please, and stop picking on my client, co-counsel might not have been so inclined to be like, so he might not have been like, well, prove it then. If you're at all these doctor's appointments, just prove it. Just prove it. If they had worked together better, this might not have been such a big deal. Like in criminal, generally, if an attorney came in and is like, look, we lost a parent, and this happens. This happens in life. This happens in court. Like, look, counsel lost a parent. It's going to be a few weeks. Everybody's generally chill about it, especially in criminal court. If the time can be waived, everybody's normally pretty cool. But yeah, this is This is attorneys that hate each other, clearly, at this point. Somebody made this go off the rails, and I want to know if that's actually his butt or not. Like, is this your butt, or did you just Google like boil butt pictures? I don't know. Oh, so maybe it is. You guys are like, are you implying catfishing? Maybe it is a catfished butt. How do we know? There's no evidence that it's actually his butt. Lindell said, because demonetized. Sure. Thanks for being amazingly you. You're welcome. I just can't with this. This calls for a collaboration with Dr. Pimple Popper. I mean, we might need an expert opinion on the butt. And to think we felt bad for the research attorney and the Tati without a crystal ball case. Yes, yes, yes. This poor research attorney is like, I didn't need that. But also, these attorneys have gone off the rails. I like reading everybody's emails. Look, I'm happy to read a snappy email thread. I'm nosy. I enjoyed being a research attorney. Though, as a research attorney, I definitely got some weird shit. Never a picture of a butt, though. There was one case that had pictures of Snoop Dogg involved, but that was as a DA. That was not as a research attorney. I would have thought the appropriate response would be a letter from his doctor, but hey, what would I know? I would have thought so too. Just a letter from their doctor would have worked out all of this. Watermark all photos is a very fair point. So I'm going to try to get to a few more super chats, and then we're going to move on. As RN, pick really not that bad. Also, there are standing desks to work from. There are standing desks to work from. Also, you can lay down and type on a laptop. It's data, not data. I mean, okay, metadata, meta something. And tech is letting me know we're already demonetized. We're yellow, folks. Did we think we wouldn't be? It's fine. Look, sometimes we need to deal with lighter topics because what comes next is not a lighter topic. So at least we got to follow the upper deck butt case, and I feel bad for all the lawyers involved, though now I kind of want to reach out for statement from both of them. I'm fascinated. I'm not letting this one go. This one has like piqued my curiosity. We're going to keep following this just to see how much the lawyers get at each other's throats, because don't we love a sassy lawyer battle sometimes, especially when one of them is like, fuck it, here's a picture of my butt. Let's be glad he didn't provide proof. I mean, that's true. He could have included a certificate. There's ways to do that with grace. This is being handled with hot mess. I just Googled infected butt for science, and don't do it, kids. That's fair. That's fair. It's fair. It's fair. How do I know that's your butt, Emily D. Baker? I mean, look, here's the thing. When you're a lawyer, when you think like a lawyer, you're like, okay, but you said that it is. But how do you prove that it is? Because what you haven't proven is that belongs to you. How do we know that belongs to you? You know, I hate to do this after we come off this rousing topic, but we are like almost an hour in, and we have a sponsor for tonight's stream. I didn't think I would be talking this long because we have 2 more very thorough cases we have to get to, and I got so distracted by butt stuff. But if you are going to Google this kind of stuff on your computer, you might want to consider a VPN. That's all I'm saying. Before we go any further, I want to take a moment to thank today's sponsor, NordVPN. We've talked a lot about data breaches on this show, particularly with that huge Twitch data breach. And what you don't want is your information just freewheeled out on the internet where it can be grabbed by those who are looking for it. NordVPN is created by cybersecurity experts and encrypts your data as it moves through remote servers so that it cannot be tracked back to you and is not identifiable to you. The thing I really appreciate about Nord is they don't keep logs of that data either. So even if they ever got breached, it can't be unscrambled, if you will. But again, cybersecurity experts, which is why my family and I use NordVPN. You can use it on up to 6 devices. desktops, laptops, phones, iPads. We use it across all of those devices. It has a really easy app that you can just like plug it into your phone, particularly when you're traveling. I use this every time I travel. Nord has a 30-day money back guarantee, so there's no harm if you go ahead and try it. You can use my code, Emily D. Baker code, and you can go to nordvpn.com/Emily D. Baker to get 4 months free and a huge discount off your 2-year plan. Did I mention it doesn't slow down your internet? Yeah, I use Nord while I'm streaming and it doesn't slow down my internet. I have put that to the test. Nord is the fastest VPN on the market, and that is critical when either you're trying to stream games or you're trying to stream, content. So go ahead and check out NordVPN. Go ahead and use my code and let me know down in the comments if you use a VPN. And again, a VPN is a virtual private network. That's all you need to know. Private, making your data private as it goes out to the interwebs. Thank you so much, Nord, for being so generous with this channel and being such a great sponsor and making a product that my family and I use so much. All right, let's get back into the legal stuff. Back to the legal stuff. Back to Tom Girardi meets murderous conspiracy meets old town Southern lawyers with generations of wealth. It's amazing. Call me Al. Yes, tonight is the polar opposite of last night's Thirst Trap Law. If you don't know what you don't know, it's a lot. If you missed it, you missed it. So let us move into this Murdaugh case. Look, it is sad. It is fascinating. I'm going to just swoop and then we're going to get to the H3H3 filings. If we don't get to all of them, we will pull up the rest of them, but we have so many lawyers in the news tonight. This Murdaugh case, man, if you guys aren't following this from South Carolina, this attorney, we're just going to go through a quick timeline and then we're going to go up to his most recent arrest. He was just arrested again. He's now been arrested twice in the last few months, but we've got to back up a little bit. His family are like 3 generations of solicitors for their 14th Circuit in South Carolina, which covers a bunch of counties that I might pronounce wrong because I've never been to South Carolina, but it's on my list. Allendale, Beaufort, Colton, Hampton, and Jasper counties in the South, the Low Country of South Carolina. And that being the solicitor is like being the DA. It is the lead prosecutor. Members of his family, well, men of his family, held that position from 1920 to 2005. But this story kind of picks up because it's all interconnected. In February 2019, his then 19-year-old son, Paul Murdaugh, crashed the family boat going over 30 miles an hour into a pier. There were 6 people on the boat, including the dad, whose name is Alex, but he seems to say it Alec. So Alec. If I go back and forth, I apologize, but it's spelled Alex, but he seems to pronounce it Alec. I don't know these things. Either way, he crashed the boat into a pier going more than 30 miles an hour. There were 6 people on the boat, including his father, which I thought was interesting because if your 19-year-old's about to crash into a pier, one would think he would say something. Unfortunately, one on the boat, a 19-year-old named Mallory Beach, was killed and 2 others were injured. 19-year-old Paul was under the influence of alcohol. Boating while intoxicated is just like driving while intoxicated. It is a crime. You cannot do that. So he was charged. Sam Munoz, it's so good to see you. Yay. I saw multiple reports that he was on the boat. So you guys are saying dad was not on the boat, but the reports that I went through all said dad was on the boat. So I will look at it again. But the reports I went through today said dad was on the boat. He might not have been, but that is what it is. So I will look again, but I saw multiple reports that dad was on the boat. Everybody's like, nope, dad was not on the boat. Okay, fair enough. I will go back to my, I will go back to the multiple articles that said dad was on the boat. I don't doubt that dad owns the boat. I don't doubt that at all. So either or, I will now I want to know from my sources. So y'all, I trust the chat more than I trust the mainstream media who says dad was not on the boat. So Chat says dad was not on the boat. The son was charged with the 3 felonies, including boating under the influence, while injuring somebody, boating under the influence while killing someone. Generally, those 3 charges are for the 3 people that were injured. So that is what that boat crash was, with the son, who was 19 at the time. 2 days later, the family housekeeper, Gloria Satterfield, died. Well, she didn't die then. She did die then. She died after a fall at the house. No autopsy was performed. The Murdaugh family told her family that she had tripped over the family dog. She had been in a coma for, it looked like 2 weeks, but for a number of weeks before she passed. It was odd that no autopsy was ever performed after a fall like that, but we will come back to that later. So that was February 2019 that those 2 things happened. On June 7th, 2021, his wife and that son, Paul, now 22, were killed at the family's hunting estate. Alec was the one who discovered them and calls 911 to report them. He was confirmed by his lawyer at a later time to be a person of interest in the case. So you've got those 2 cases from February 2019, and then the murder of his wife and son at their hunting estate. So then we get to June 10th. Alex Murdaugh's father passes away. So now you've got the June 7th killing of his wife and oldest son. Then you've got the passing of his father, which seemed to be from natural and age-related causes. Then, that's June. July, there are court filings that allege a civil conspiracy connected to law enforcement with regards to the boat crash. I have not pulled up the legal documents from any of this yet, but I'm going to be doing a deep dive because there is so much to cover, and I feel like the court documents will clear things up. This is why I don't always love relying on media reports, and I like having the news stories, but I wanted to touch on all of the things before we get into everything. So apparently, Alex Murdaugh is a person of interest. He says he was visiting his mom, and he came back from visiting his mom and a caretaker were both there when he was visiting his mom, who reports say has dementia. On September 3rd, Alex Murdaugh resigned from the family law firm. I feel like this moment is the Edelson PC filing of it all. Maybe it's the divorce. We'll have to correlate this event to what it would be in the Girardi case, but I feel like this is the Edelson PC filing of it all. He resigns from the family law firm, and a statement from the firm indicates that he had misappropriated funds. This is a family law firm. Yes, others work there. This is a very well-respected Southern law firm, but then there are also these indications that he misappropriated funds, hence the Girardi of it all. On September 6th, Murdaugh enters rehab. It's indicated later that he is suffering from an opioid dependency. Unfortunately, that's way too common in the profession of law. It is common not just in the profession of law, but in the US in general, but not uncommon in the profession of law. On September 13th, state police open an investigation into the law firm and what they've been up to, which, happened pretty quickly. He was also in this time period, and I don't have the exact date. I think we're going to have to do a deep dive on the podcast. That's my goal. He's also suspended from practicing law. Like in this period of time in September somewhere, it seems that he is suspended from practicing law. On September 14th, Murdaugh, no, where is it? I missed it. We missed one important date. September 3rd, he resigns from the family law firm. September 4th, how did I miss this? September 4th, he is shot in the head. And the initial story is that he was pulled over changing a tire when somebody drove by and shot him. Susie Rose, no, I didn't say I believe Trump's claims that mainstream news is reporting fake news. I believe that news does not always get it correct, and they do not look at it through the same lens that I do, which is why news reportings of court documents, I prefer to go to the court document because I don't want it third hand. I want to see what the court documents say because I find everything is filtered through someone else's lens, and the lens of a reporter and the lens of a lawyer are two different things. So no, I don't think that the media always gets it right. I do not. Any of the media. So that is just the way it is. Look, I read 2 different media reports that dude was on the boat, and the chat is like, no, he was not. So it happens. Media does get things wrong, but I want to read the court documents. And this is why. Because the court documents, though court documents are allegations and shade, and they are allegations, at least I know what the court documents say versus what the media says the court documents say, if that makes sense. So, September 4th, Alec is shot in the head. There is a lot of disagreement about what went down with the shooting in the head. The police report said that he had minor injuries. His lawyer said that he had a fractured skull and an entry and an exit wound and a brain bleed and was in intensive care. There is a large divergence about what happened with that. So then September 6th, he enters rehab. But also, if you get shot in the head and you're in intensive care, how do you enter rehab 2 days later? How? Like, it can't be that bad of a head injury if he entered rehab 2 days later, because you wouldn't be out of the hospital. Like, that's just the timeline doesn't add up there. So September 4th, he gets shot in the head or not. September 6th, he enters rehab. Then the law firm indictment. Then on September 14th, Murdaugh confesses that the shooting in the head was an assisted suicide plot so that his life insurance of $10 million would go to his remaining son. So then Curtis Smith, who had been a client of Murdaugh, was charged with the shooting and charged with assisted suicide, conspiracy to commit insurance fraud, and insurance fraud. Murdaugh's lawyers still say that he was injured substantially. Smith and his lawyers have given numerous news interviews and say that that he wasn't shot, and that when Smith showed up, Murdaugh had a gun and Smith was trying to wrestle the gun away from him so he wouldn't commit suicide, and then the gun went off. There are a lot of discrepancies in the story, and everybody's given interviews to the news. He had a craniofacial infection. I mean, Murdaugh's lawyers say that Smith was Murdaugh's drug dealer. Smith said that he interrupted the suicide attempt. Smith has given an interview on the Today Show. Murdaugh's attorney gave an interview on Good Morning America. Like, everyone is having conversations. September 15th, a criminal investigation is now opened into the death of Gloria Satterfield. And I apologize if I mispronounce it, but Satterfield, regarding the handling of her estate. A civil lawsuit was filed by her sons against Murdaugh and the other attorneys. She is their housekeeper who passed away after an incident in their home. They said it was a trip and fall over the dog. There was a multiple $million settlement. And with that multiple $1 million settlement, it seems that her kids did not get the money. That's what they're alleging. And a criminal investigation was then opened up. On September 16th, Murdaugh was charged with insurance fraud, conspiracy to commit fraud, and filing a false police report with regard to the shooting incident. On October 14th, he was arrested. On the September 16th, he was arrested. He bailed out, shocking, and then went back into rehab. Yesterday, October 14th, Murdaugh was arrested in Florida when he was leaving rehab on 2 counts of obtaining property by false pretense with regard to the misappropriation of the money and the proceeds from the death of Gloria. So all of this has led up to he's in custody now. And then today, his lawyer went on Good Morning America and said that, he had done some things. And we're going to watch a little bit of a clip of that right now. So let me pull that up so you guys can hear the audio. It is just the craziest thing I have ever seen. I am glad there's a criminal investigation opened with regard to the housekeeper. I feel horribly for her children. Again, for anyone who is, um, having to deal with the injury of someone, the death of someone, and then having to go after their lawyer again for the funds they're supposed to have is devastating. I hate it in the Girardi case, and I hate it in this case. I am very distracted by my large child while I am live streaming. You came to claim a cat? Did you sneak in to claim a cat?
No, I just want to say hi to the cats, and it's not my fault you're live streaming. The cats are in here. And
the cats like hanging with me. You're welcome to hang out with the cats. We're going to watch a little bit of a clip. Oh, and then will you ask your dad what temperature the AC is set to? Because I'm really warm. You're the best. It's warm in here, right? I think it got turned off. So everybody's asking, what did the housekeeper know? Yep. We want to know too. Okay, let's fair use a little bit of this clip. And everybody's like, it was chutney. I mean, she thought it was you coming through the door. There is so much mystery and intrigue around this case. It is very, very confusing. So this needs I need to pull the court documents because I want to see, but there are like a lot of different court documents going on. And it was supposed to be one of my lawyers in the news, but then we got distracted by butt stuff. And now we're here an hour in and we're going to watch this clip, but I've got to reshare it because I want to have audio with it. So this is from Good Morning America. Let us just share that. This is from their Twitter account, so it'll be a pretty quick one, and we'll do a little commentary in between. So let me pull this up.
They don't put people in
Hold on. This is the lawyer for Murdaugh. He was arrested again yesterday, and the first thing his lawyer did, it seemed, was go on Good Morning America and have a chitty chat. Let me know in the chat if you can hear it when it starts playing. I'm going to hope that that's like a yes. Let's see. This has not been going well for me lately trying to play videos. So fingers crossed, everybody. Perfect. It's glorious. The anticipation's glorious. This might just have to go in the podcast episode. It was literally playing before I made it big and tried to put it on screen. I don't know if this is a StreamYard issue or if this is a me issue. Oh my goodness. It's every single time. Every single time. Nope. All right. Boo. I will share the link out. I don't know why that's not playing. I am very disappointed. Let's see. No, it's every time I'm sharing. Every single time. Look, live streaming, it's hard out here for a live streamer, folks. It just is. If I stop sharing it, does it make it better? Maybe it has stage fright. Maybe it just has stage fright. Let's see. We're going to stop sharing and then see if that works. I think it's because it was playing when I wasn't sharing it. I wonder if it's a sharing thing. Yikes. All right. Well, it's not playing. I'll share the link to the tweet on my Twitter. I'm just going to go ahead and retweet it. I will clip this into my, my stream my podcast episode of this. Oh, George is leaving us. George is like, yeah, I'm going to go follow Travis. Travis is going to play with us. So, all right. Well, the GMA exclusive has been retweeted on my Twitters at the Emily D. Baker. If you are not on my Twitters, it's over there. We'll put it into the podcast. The times when Emily's like, do we need a new computer? Apple has an event next week. Maybe we need a new computer. Maybe we do. And yes, that really is the lawyer's name. The lawyer's name is really Dick Harpootlin. Harpootlin. That is the lawyer's name. I don't know, man. It is what it is. I don't know. That's his lawyer's name. Let's see if this will play this way. Now that we have done it the other way. No, Nope. It was auto playing before I wanted to share it. And now it's like, no, fuck you. What we're not going to do is play your video. We're moving on. Because we have so much stuff to talk about with H3 and freaking Triller. So Alex Murdaugh is in jail. There is a lawsuit with regard to... Oh, now it's playing. Oh, now you want to play? Really good morning, America. One more chance.
Joining us again this morning. You recently said, no question, Alex Murdaugh has done some things that he regrets. What are those things?
Yeah, it's still not working very well. All right. Oh, you know what? I bet I have this from YouTube. Let me see if I have the link to YouTube. Because if I was smart, I would have done that. All right, let's see if we can make this work. Let's see if we can share a clip. YouTube. It's fair use, and then we're going to Triller. Let's just see if we can get to this part with Stephanopoulos talking about. Nope, it was not playing either. All right, screw you then. Screw you guys. I'm going home. We will be covering this a little bit later. It is needed. There is a lot more here, and I want to pull up those the court documents. So the cases that are pending are civil cases with misappropriation, and then the 2 criminal cases, and then the investigation into the death of the wife and son, the investigation into the death of Gloria, their housekeeper. There is a potentially related death that a new investigation has been opened up into that it looked like a hit and run. There is a lot of investigation going on into deaths that are currently unsolved with potential connection to this. It is very, very interesting. So, yikes. Are we ready for Triller? Triller. No, I'm ready for Triller. Triller, with regard to Triller had their, oh, I should swoop. Look, I got all discombobulated. Swoop. With regard to Triller, they had their case in the sassy Judge Anderson's court dismissed for lack of prosecution, meaning they never served the filmdaily.com that they were trying to find. This is why you have to research these things before you file the lawsuit, because then it gets yeeted right out of court. He's snoring. Fred is snoring. But they got yeeted right out of court, which I can't say I'm sad for. I'm only sad that it hasn't happened yet with regard to these Triller cases with Ethan Klein and H3. However, it is now for our entertainment. And so, unfortunately, that comes at expense to Ethan and Hila and their companies and personal stress and anxiety. But for us, we just get to look at all of the Trilleriness. So the first thing we're going to look at is the federal case. Remember, with Triller, there are 2 cases. There's a federal case and a California case. The California case is the case where they're really angry over your thing being flipped. We're going to get there next. The federal case is with regard to Triller suing H3H3 along with everyone else, including Mike, all of the things, suing all of the people, trying to say that there is some kind of infringement of copyright. Yeah. So plaintiff filed, or defendant Ethan Klein filed, a motion to dismiss the second amended complaint, the SAC and the FAC. We talked about the SAC being flipped, and we talked about that case. So this is going to be the plaintiff's opposition. A lot of these have been skimmed. But let's talk about them. Plaintiff's opposition to defendant's request for judicial notice. No, that's not the one we want to do first. Let's see. Where is plaintiff's opposition to defendant's motion to dismiss SAC? Filed concurrently with the declaration and the opposition. Table of contents. Yay, there's a table of contents. I mean, I feel like we're moving on up. We know what the introduction is. We know what this case is about. This is not the first time defendants have profited by piggybacking off the creative work of others. That's where we're going. Okay. Nor is it the first time defendants have found themselves in court as a result of such. Indeed, as the defendants proudly proclaimed just a few short years ago, defendants were sued for admittedly using at least 60% of the creative work of another YouTube content creator. See Haas v. Klein. Although defendants were able to successfully invoke the fair use doctrine in Haas, the facts of Haas are distinguishable in at least 3 crucial ways. In Haas, the copyrighted material at issue was not published on a limited pay-per-view basis. 2, defendants did not admit to having unlawfully bootlegged or pirated the copyrighted pay-per-view material at issue. This is not, that's not going to go that way. It's everywhere on the internet. All right. All right. 3, defendants did not republish an unaltered version of the copyright pay-per-view material at issue so that others could unlawfully bootleg or pirate the same. That's like not what happened. Okay. Okay, Triller, that like you get to have your side, but that's not the way that went. And also, the fact that they used more of Haas's content and less of your content doesn't go in your favor. That goes in their favor. This lawsuit does not concern or seek to stifle defendants' commentary relating to the broadcast. To the contrary, this lawsuit concerns defendants' creation and dissemination of the unlisted video that wasn't disseminated. It's an unlisted video. That was unlisted for the purpose of using it in commentary. Okay. Plaintiff does not seek to silence defendants, but rather halt and prevent defendants from blatantly infringing on plaintiff's valuable copyrights. Then go take it down all over the internet because it's still up. I bet you it's still up on Mike's channel. Let's find Mike. I don't know if we can find Mike. Hold on. Let's see if we can find Mike. I'm going to pull up the other. I might have to pull into my drive. So we don't want to expose my drive. Also, there's like 3,000 of you watching. Hey, y'all. Thank you. Don't forget to do the YouTube things. I'm literally putting in Mike. And all I'm going to get is this Hump Day commercial. Damn it. Hump Day. I'll have to go find the link on another one. Mike fighting Triller. I don't know if that's gonna come up. Nope. Triller is a joke. Nope. All right, nope. All right. Before we get down a rabbit hole, we got to get through these legal filings, and I'll pull it up another time. I bet you it's still up. I'll find it. To the extent defendants wanted to provide commentary concerning the broadcast, defendants could and should have done so without violating the Copyright Act by hiding, obstructing, or obscuring the URL of the unlisted video. But whether out of negligence, willfulness, or maliciousness, or some combination thereof, defendants chose not to hide, obstruct, or obscure the URL for the unlisted video, and thereby permitting at least 65 individuals to view the essential portions of the broadcast without paying plaintiff the required pay-per-view fee. That means, somebody do the math. What was this, a $50 pay-per-view for 65 people? I bet you Ethan Klein would settle the case for that to just make you go away. Like 65 people by $50. I don't know. You've just limited your damages in your own argument. So therefore, your damages, if they are that, can't be more than that, but also prove that it's 65 different people and not 65 views internal to their prep for their case. Also, not just that, but it's only a fraction of the fight. So people are like, all right, $3,000. I mean, right? I think they just limited their findings. Somebody said he offered to settle for $10K, and I haven't watched all of their content on this, but I wouldn't offer to settle for $10K. I'd offer to settle for like $5K. Be like, here you go. Here's $5,000. If you think that the heart of this case, and this is what Triller's saying, they're saying the heart of this case is the uploaded video that possibly 65 people saw, that got 65 views. That doesn't mean 65 unique viewers. I'd love to see the analytics on that, because the analytics in the back end of YouTube actually show unique viewers. And I bet the unique viewers is less, because I bet you they pulled it up a couple times to prep for the show. Okay, your damages are now limited to $5,000. If your damages are limited to under $5,000, then this does not have jurisdiction anymore, because the matter in controversy is now under $75,000. So you have just argued yourself out of jurisdiction, because you've just argued that the only issue here is the unlisted video at 65 individuals, which is like $5,000. Yeet thyself. You no longer meet the $75,000 threshold to get into federal court. Bye-bye. 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 But that's just me saying that they've now argued against themselves in their own motion, because I would use their own motion against them. At stake in this case is the incentive for content creators like plaintiff to expend vast resources organizing, promoting, and exhibiting creative sports. Is that what we're calling it? Creative sports? Is that that's what we're going with? Cool. And cultural. Oh, it's a cultural event. Okay. Cool. Cool. Cultural events like the broadcast versus the freedom of others like defendants to illegally bootleg or pirate such events. If the issue is the alleged bootlegging, then your case in controversy is $50. Bye-bye. That's it. That's the harm done. Statement of facts. We know the facts. The essential facts are largely undisputed. Plaintiff is the copyright owner. Plaintiff's copyright in the broadcast bears the registration number. Ben Askren fought one of the Paul brothers. Things happened. It was commented on the H3 podcast. Teddy Fresh is not involved. They keep trying to make fetch happen, and fetch is not happening. Defendants admit they illegally bootlegged or pirated the broadcast without paying plaintiff. By the way, they said that in a stream, not under oath. And it just reminds me of the scene from Dazed and Confused, where he's like running out with the beer, and then there's like a dude with a shotgun who's like, and somebody's like, give back the beer, man. And he's like, I paid for the beer, man. Because he pretended he stole the beer, but he actually paid for the beer because he wanted his friends to think he stole the beer. Like, look, Ethan Klein saying on a stream that he bootlegged or pirated the stream doesn't mean that he actually did it. It could mean that he said that he did it because he wasn't going to admit to giving the Paul brothers any money, which is fine. You don't have to, you're not under oath. You can say what you say on a live stream. That's not, it might be a prior inconsistent statement to something down the road, but it's not sworn testimony. Ugh. Okay. We're going to move on. According to YouTube, unlisted videos. Yeah, we all know what an unlisted video is. We got it. They uploaded to the YouTube channel a new episode of the H3 podcast. We know. Do you have anything else to do other than say that you're now not at an amount in controversy? Like anything else? Do you have anything else to add that's helpful to your case? Because right now, nothing's helpful to your case. We're gonna finish this whiskey and just go off on Triller a little bit more. Sure. Defendants implicitly admit to vicariously violating the Copyright Act. Vicarious infringement occurs when one profits from directly infringing while declining to exercise a right to stop or limit it. What? Defendants claim they did not violate the Copyright Act because they did not zoom in on the references video's URL. True. Direct video viewers to watch the reference video. True. State the reference video URL. True. You could barely see the reference video, and it would take quite a lot of work to guess at the reference video URL. Defendants did not merely watch a transmission or create a stream. Defendants take the position that Triller's copyright infringement claim relies on Ethan's statement that he bootlegged or pirated the April 17th, 2021 transmission of the broadcast, and falsely assert that viewing a transmission, whether it be on Triller's April 17th transmission of the broadcast or the reference video or the 4/22/21 podcast, does not constitute copyright infringement because it was not a public performance of the work. It fell under fair use. These are all the elements for fair use. They're just saying it in a really long way. They're saying, no, they're arguing fair use. Yes, they're arguing fair use. Defendants make much of Copyright Act's requirements that a certain material be fixed. Yes, they did. I thought it was a good argument. We're not going to parse through all of the arguments. They say it's not fair use. Fair use is inappropriate at the motion to dismiss stage. Fascinating. Because fair use is a defense. And if it is fair use, then it cannot be copyright infringement. So in fact, it is appropriate at a motion to dismiss stage. But also, failure to state a claim. Defendant's sole defense to plaintiff's claims is fair use. I think they had other defenses that they added. Where does it say that fair use is not appropriate in a motion to dismiss? Because I'm not seeing it. It says, indeed, due to the fact-sensitive nature of the inquiry, courts generally do not address the fair use defense until summary judgment. Okay, there it says. But it says generally. I don't think there's a lot of dispute about the facts in this case. The facts are the facts. They dispute how the facts should be interpreted. And that is appropriate in a motion to dismiss. Defendant's bad faith counsels against defendant's ability to invoke the protection of fair use. What bad faith? Okay. To invoke the fair use exception, an individual must possess an authorized copy of the literary work. So that they are trying to say this is an unauthorized copy because they are saying it is bootlegged. The Copyright Act, let's see. We have previously held that the Copyright Act does not distinguish between unauthorized copies of a copyrighted work on the basis of what stage of the alleged infringer's work the unauthorized copies represent. Explaining that Sega and Atari suggest, among other things, that fair use is unavailable where the defendant does not possess an authorized copy. That does happen in gaming cases, in particular when people use unauthorized game copies. But that argument, if that was their best argument, they should have led with it. Defendants did not obtain the broadcast lawfully. And again, if they did, they can prove it pretty easily. Indeed, but that again is $50. Really, the damages would just be limited to the cost of the thing. I don't think they would be able to expand that. Let's see what else. They're going on to talk about the good faith and harping really on the Atari Games case, which might be their best argument in all of this is, look, the unlisted video was an unauthorized copy. And because it was an unauthorized copy, it can't be fair use because it's an unauthorized copy. The intermediate use doctrine does not apply to defendant's conduct. We went through that. I'm not getting into the tit for tat of it because we'll be here forever. They go through the weighing of the factors. I think it's fair use. I think their strongest argument is definitely going to be that it's an unauthorized copy. That might not matter in the end. I would need to look. I'll be interested to see H3's response. I think they filed it in this one. The alter ego allegations are stupid. I'm not going to go through them. There's no way that Teddy Fresh is an alter ego of the H3 podcast's production company. It's just not. It's just not. Teddy Fresh is a completely separate and distinct entity. So the entities have the same business office. That doesn't mean they are the same. Teddy Fresh is a clothing company. H3 Productions is a production company. The Triller's like, Triller wants the 5%. That's what's happening. Triller wants the 5%. That's where we're at with those. I love an inter alia argument, like arguendo. To the extent the court is inclined to dismiss any of plaintiff's causes of action, plaintiff respectfully requests leave to amend the court. And they're saying, look, if you're going to dismiss it, let us amend our SAC into a THAC, to a third amended complaint. Let us try to fix it. And at the motion to dismiss stage, a lot of courts will give a lot of leeway to amend it because they don't see it as equitable as dismissing everything and then having you have to file a new lawsuit. So they may, if they're inclined, allow another amendment of this complaint, which would just be fucking annoying. But we'll see if they can do it better. There is a declaration. Plaintiff owns copyright. We're not arguing that they don't. I've reviewed the publicly available filings. This is the company of TEI, which is the broadcast company. They're arguing that all the filings are saying, look, Ethan Klein and Alex Klein both own Teddy Fresh and they both own the production company. So that doesn't mean they're alter egos of each other. It's a okay. Something is squeaking on my desk and I have no idea what it is. Maybe it's me. All right, we're going to the next document, which I think is the Opposition to the motion for judicial notice. We don't have a reply yet for Ted, for Ethan and Ted Entertainment. I'm sure we'll get one, but we don't have one yet. I don't think it's due yet because this isn't being heard till November 22nd. I'll be very interested to see what the court does. They are objecting to the motion for judicial notice. Let's see what they say. What? Not much. What items did they cite? Oh, this is not easily formatted. Rude. Plaintiff Triller Fight Club respectfully submits this short opposition to the request to take judicial notice of one. God, this is poorly lit. Triller's initial complaint against Film Daily, Triller's first amended complaint against Film Daily, Judge Percy Anderson's order to show cause. Okay, all the things. Why? The unrelated filings concerning the Film Daily action, not this action. Well, you filed this action as part of the Film Daily action. They are related. Defendants are not parties to the Film Daily action anymore because the court threw it the fuck out. Defendants do not seek to introduce the unrelated filings because they bear upon or have any relevance to the issues raised in the action, but rather to prejudice Fight Club. But we don't talk about Fight Club. I thought we don't talk about Fight Club. Accordingly, defendants' request for judicial notice should be denied because the unrelated filings are inadmissible. So you're saying they lack relevance. All right, well, we'll see what the court does. I think they're relevant. They think they're not relevant. They think they're unrelated. We'll see what the court does. I think the court's going to be like, I can determine how relevant they are. No harm, no foul. FRE 401 is relevance. The fact that I still remember that, is because it's hammered into one's head. And then 403 is the balancing of prejudicial weight versus probative value. But this is just the court determining these things. And the court can go, look, this is not just prejudicial. I can parse out what happens. And it's different than admitting it to a jury. So I don't think that's going to be an issue. We should get to the California filing because there's a lot going on in that one too. And that filing is also flipped. So let me go ahead and pull that one up. I'm trying not to overload my computer since it's being so salty with me. And then we're going to have to get to a little bit of COPO. So let's pull this back up because, of course, I closed it because why wouldn't you? We're professionals here, especially on a whiskey stream. It's been a while since we've had a whiskey stream. Look, we drank last night on the members only live stream. Tonight also required a drink because we're knee deep in fuckery and butt boils. Emily, do you ever want to be monetized again? Meh. Monetization's nice. We would like for it to happen. All right, let's get to, there are so many filings in the California case. Let me see which one I want to start with. You guys are like, this is fascinating content, Emily. Yes. The California filings. Let's swoop and talk about the California filings. The California filings are the one where Triller is suing TED Entertainment, which is the H3 production company, Teddy Fresh, Ethan Klein, and Ela Klein over essentially shit that was said on Reddit and app reviews that were not submitted by Ethan. We're going to start with the first amended complaint because they did file a FAQ. We're just going to real quickly run through the FAQ because we have other things we need to get to that's funnier. So a permission to laugh at this lawsuit granted for all of you. Permission to make fun granted. We've dealt with heavy topics around here. We're going to make fun of all of the things Triller's complaining about. We just are. The nature of the action. This is a defendant started by war. No, this is a case. How do we rephrase the Toddy Westbrook, Clark Swanson? This is a case because of the defendant's greed. How do we start this one? This is a case of the H3 podcast going to war. Foot soldiers assemble. This is the nature of the action. And this basically sums it the fuck up, doesn't it? This is war. H3 After Dark going live shortly. Foot soldiers assemble. On April 2021, defendant Ethan Klein publicly admitted that he bootlegged or pirated certain. They are so angry. certain copyrighted materials belonging to Triller Fight Club. And look, DJ Screwdriver Media Post at Media Post DJ from Twitter. We're going to pull that up in a second. It probably won't work, but we'll pull it up anyway. Look, we have covered the Ami in a Hellcat suit with regard to copyright, where he's facing like 500 years in prison over a $30 million copyright infringement case. That shit, those allegations are bad. This is not that. Large scale copyright piracy. Copyright piracy is a problem. I am not making fun of copyright piracy. I am making fun of this ridiculous vendetta that is going on between Triller and Ethan Klein, because this is ridiculous. And this one is mostly because they're mad that Ethan said it's flipped, which isn't even what Ethan said. Let's see if we can pull up this post. Yay for hyperlinks. Whoop, whoop. All right. I'm not sure. I'm gonna turn my, oh, see? It's only 13 seconds long. I'm gonna turn my volume up. And I'm gonna hope for the best. I'm sure we've all seen this clip. I'll just retweet it. But my computer just can't hang. Motion for a new computer. I think maybe. Do you think we're gonna get M1 iMacs? Like, I love my iMac. I don't love this that happens when I'm streaming. I need to have a conversation with StreamYard. Be like, why? It's only when I'm streaming. When I'm not streaming, this doesn't happen. Ugh. But he says it. But again, is he being serious or is he not being serious? We don't know. I'm going to let it see if it can resolve itself. Let's see. What else do I have open that I can close? Emily, stop trying to make fetch happen. I know. I have everything else. Well, not everything. We're overclocking the hard drive. We need to bypass the converter. No, the compressor. We need to bypass the compressor and make this work, and it's just not happening. All right. Give up, Emily. Give up. It's not happening. Clearly. All right. Let's get back to the California case. If we hear Ethan in the background, then we'll know it started working on its own, completely sua sponte. But I will retweet that again at the Emily D. Baker. It hath been retweeted. Retweeted? Retwittered. It's been retwittered. All right. In response and to protect its valuable copyright. Say valuable one more time. It's valuable copyright. And other business interests, Fight Club filed a lawsuit against Mr. Klein, Mrs. Klein, TED Entertainment, and others in the United States District Court. We know, to detract attention from the copyright action and in a deeply misguided attempt to exact revenge for the copyright action and to gain an unfair advantage in the highly competitive entertainment industry, defendants announced that they were going to war with certain affiliates of Fight Club, including Triller Inc. and Ryan Kavanaugh. Why is this spaced so close to the line? Why is it formatted like this? I don't know. I feel like my motion for an M1 Mac has been granted. Thanks, team. Everybody's like, do it. So we want to have video clips. Yep. You guys are like, but it could be your internet connection. True, but doubtful. My internet's pretty fast. It's only when I'm streaming that this shit happens. Only when I'm streaming. Anyway. It's another thing. I think it's whatever. Back to dramatic reading. In furtherance of that war, defendants specifically instructed their rabid fans. Did you know you were rabid? Known as foot soldiers, to leave thousands of negative so-called troll reviews for Triller's eponymous. What does that even mean? This one I don't know. And I don't know how to pronounce it. Their app. In the App Store and Google Play Store. Footnotes. To troll something or someone is to, quote, write false or offensive messages on the internet in order to make other people angry. Troll. Oxford Learners Dictionaries. I like the definition of troll. See video and the number of babies is available at this is the guy I'm going to war with now while showing results of a Google search for Ryan Kavanaugh. Look, no one thinks he means anything. Thank you, chat. You are so wise. Oh, wise chat. We appreciate you. A number of you were like, Emily, we know. Look, we've learned something new. We've learned something new today. It is not a word I knew. Triller's app named Triller. Perfect. We appreciate. Thank you, Triller. Triller lawyers. I have learned something. This is the first time I've learned something from one of your filings, other than that lawyers can actually file a federal case without putting dates in it, which I didn't think would happen, but I didn't think we would have butt photos. So, I'm astounded every day. But thank you. I have learned a new word. I am excited. We are very pleased. Thank you, Triller. Credit where credit is due. We got a new word. That's all I'm going to take away from this. We've already been through this. This is the fact. This is the take down Triller. Let's all rate Triller on the 1-star app store. This is all from Reddit. What you can't do is hold somebody responsible for what somebody else says on Reddit. That's not how that works. They're trying to do it. I love that even the footnotes have the emoji. These are the Reddit posts. This is the Ryan Kavanaugh photo. All of you foot soldiers in the chat, just put feet emojis in the chat if you're also a foot soldier, because I'm just curious, but also look, what someone says on Reddit, A, generally First Amendment protected speech, but 2, it can't be attributed to Ethan Klein, Ela Klein, and Teddy Fresh. We know that. Let's see if there's anything else in this fact. The alter ego allegation. You know how Emily feels about trying to make Teddy Fresh part of all of this. It's just not going to happen. I see all of y'all. I see you. Thank you, everyone, for humoring me in the chat. We're going to continue on because we've been through this full complaint. So today's not the day to go through this complaint. I just wanted to see if there was anything else new, and there isn't much. We've already gotten through the motion to dismiss on the fact. So let's pull up the actual new shit. That was filed on September 29th. Let's see. These are the evidentiary objections to Ethan's declaration. These are the declaration of Brian. Where's the motion? Declaration of Alexander. Plaintiff's opposition to defendant's special motion to strike. So this is their opposition. Plaintiff's opposition to defendant's special motion to strike. Plaintiff's first amended complaint pursuant to California Code of Civil Procedure 425.16. Your slap motion. This is their opposition to the slap motion. Introduction. The facts of this case are simple. In response to and to exact revenge for a lawsuit filed by Triller, defendants Ted and all of them enlisted their millions of fans known as foot soldiers in a virtual war against certain of Fight Club's affiliates, specifically Plaintiff Triller Inc. That's very specific. Specifically, defendants made oral and written statements on their commercial podcast and social media accounts to instruct and encourage their foot soldiers to leave negative troll reviews for Triller. Oh, they just copied and pasted. Great. Statement of relevant facts. We know the relevant facts. What is your argument? For example, in defendant's June 11th podcast, defendants claim that Triller is Mr. Kavanaugh runs a Ponzi scheme. That's not what they said, though. Relatively, they went super bankrupt, and then he got Triller involved, and he was accused of running a Ponzi scheme. Right. What that doesn't say is that Triller is a Ponzi scheme. That's reading a lot into it. I know that this is advocacy, but I don't think people should use the app specifically because the owner is such a nasty piece of shit. Everyone, say it with me. What does that sound like? I don't think people should use the app specifically because the owner is a nasty piece of shit. It sounds like an opinion. Guess what you're allowed to have? An opinion. Are they both back there? Yep. Going back to sleep. You're allowed to have an opinion. You're allowed to call people names on the internet. Not all names. Some names you can't call people on the internet. Nasty piece of shit is one of them. You can call someone a nasty piece of shit. You know why? You don't actually think they are a literal nasty piece of feces. It is hyperbole. It is an opinion. He said, I think it is. How do they even type this without going, well, it is an opinion, but we're getting paid. So, it's cool. That's the one whose business partner said that he ran a Ponzi scheme. Well, there's an article that says that. So There's an article that said that. He's a film and TV producer, entrepreneur, and Ponzi scheme enthusiast. Also might fall under comedy, might fall under opinion, but they are very, very big mad about it. And he said, no, it's not alleged. But apropos to what? Because this is clipped out of context. But his business partner said that. So, all right. Does running a Ponzi scheme count as entrepreneurial shit? Also, not a statement of fact. Question. His partner's suing him for running a Ponzi scheme. There was an article about it. Thereafter, defendants displayed and read for their foot soldier numerous troll reviews on the Triller app, including one written by Mr. Klein himself. After hanging a framed copy of his own Triller review, Mr. Klein said, "That's my 1-star review of Triller," and implored his foot soldiers to share your thoughts on Triller. It's disingenuous, though, because after that, he said, share your thoughts on Triller, but they need to be your honest opinion. 1 star, multiple stars, leave it some stars. He encouraged people to review the app. I don't think this is going to fly. And then he said, I'll be checking in on Triller. I'll be checking in on the Triller reviews. In a transparent effort to escape the consequences of their actions, defendants feigned disapproval of the troll reviews and asked for them to leave honest reviews while struggling to stifle their smirks and laughter. They said leave honest reviews. Devil's advocate's like, I can hear Tamara Judge screaming, that's my opinion. Me too. Me too. That's my opinion. I can't believe Foot Soldiers is an illegal document. I can't believe how much Foot Soldiers is an illegal document. It's all up in here. But look, you know you've got good branding when the other side is like, oh, your community's called the Foot Soldiers. Got it. Let's talk about their Reddit. It's so funny because there are so many on YouTube that have had experiences with fan bases going after them. We've seen Gabby Hanna's fans go after people. We've seen Trisha Paytas's fans go after people. We've seen people's fandoms come after Trisha Paytas. Triller is like, I don't want any part of the internet. Look, Triller, you're the one who filed the lawsuit. And we are just all commenting on it. Honestly, with our opinions and peace and love. Oh, and whiskey. Defendants' message to their foot soldiers could hardly be more clear. Leave troll reviews for the app. They're like, oh, they dog whistled their listeners. And defendants' foot soldiers heard defendants' true message loud and clear. Since July 2021, the app has received thousands of 1-star reviews parroting defendants' allegations regarding Triller and Mr. Kavanaugh. Of the 4,868 total reviews left for the app on the Apple Store during the 2021 calendar year, approximately 2,500 or 51.5 are 1-star reviews left by defendants' foot soldiers. How are you going to prove that? How are you going to prove that they are left by fans of Ethan Klein? How? I can't wait to see Brian Blatz's declaration, because how do you prove that that's who they're left by? Okay. And of the 8,200 total reviews left in the apps, left in the Google Play Store in 2021, approximately 1,300 or 16% are 1-star reviews left by the foot soldiers. I think that's slanderous. Like, what foot soldier actually uses the Google Play Store? Aren't they all just iPhone people? What is this? How do you prove it? How do you prove it? Argument. Resolution of an anti-SLAPP motion involves 2 steps. First, the defendant must establish that the challenge claim arises from protected activity, free speech. If the defendant makes the required showing, the burden shifts to the plaintiff to demonstrate the merit of the claim. We know that. The complaint does not arise from protected activity. We're going to have to agree to disagree, because speech at issue is illegal. The anti-SLAPP does not apply. The speech is not illegal. Although stated in broad terms, the right to free speech is not absolute. There are categories of communication and certain special utterances. What are your special utterances, Triller? To which the majestic protection of the First Amendment does not extend because there are no essential part of any exposition of ideas and are of such slight social value as a step to truth that any benefit that may be derived from them is clearly outweighed by the social interest in order and morality. Bose versus Consumers Union, 1984. These categories include fighting words, defamation, obscenity, and statements in furtherance of a conspiracy. Which one is this? Because it's not, Triller, are you trying to make hyperbole fighting words? Because so there was this DA that I worked with before he left and became a defense attorney. Really big dude, tall dude, who is great DA, but can be cheeky, confrontational, can get under the skin of defense attorneys. And they were outside of court in the back hallway with the judge having a sidebar trying to settle an issue. And the defense attorney looks up at the DA and is like, somebody's about to get punched. And the DA, looking down at this defense attorney, is like, who would that be? And he's like, you big bastard. Those are fighting words. Someone's about to get punched face to face. You big bastard. Those are fighting words. And even then the DA bust out in laughter and the court was like, what we're not going to do is go to fisticuffs in the hallway. This is not fighting words. This is not furtherance of a conspiracy. This is not defamatory. But okay, keep trying to make fetch happen. I get it. You need to argue your side. The copyright action is protected speech. Fight Club has a constitutional right to seek legal redress for grievances, and H3 has the right to make fun of it. They have the right to call you out. They have the right to call you a nasty piece of shit. They have the right to make fun of people's looks. They have the right to do that. However, in an unlawful effort to force Fight Club to drop the copyright action, defendants launched a war against Fight Club's affiliate, Triller, and instructed and encouraged their foot soldiers to leave troll reviews, causing millions of dollars of damage to Triller. How do you prove it? How do you prove it? Such speech is illegal because it's part and parcel to defendants' unlawful scheme to extort Fight Club and harm Triller in violation of Penal Code 518. Oh, the stretching and reaching that is happening. Okay. California courts have made clear that where a defendant does not contest the illegality of the speech at issue, the defendant is incapable of satisfying their initial burden. Well, they say defendants didn't contest it, but we read the motion. So we disagree. They go on to say defendants have not made any statements in connection with the issue under consideration by a legislative, executive, or judicial body. So they're going into like, this is why it's not protected. They didn't make a statement in the public place or public. Defendants have not made a statement in the public place or a public forum in connection with the issue of public interest. YouTube being the public place or public forum, the fight being an issue of public interest, and the views indicate that it was a public interest. So the judge is going to have to sort that out. I tend to take the side that YouTube is a public forum. They're saying it's not a public forum. I don't think the subreddit comes into that argument at all because the statements on the subreddit can't be attributed to the clients anyway. Let's see what else they have to say. Defendants have not exercised the constitutional right of petition or constitutional right of free speech. Look, in the slap motion, they told you what sections they were arguing under. You don't have to argue under all the other ones. They can't bring up new arguments in their reply. This is just throwing more spaghetti, being like, see, Your Honor, they were not petitioning. No shit, they weren't petitioning. They don't argue that they are. Plaintiff is likely to prevail. Let's see. Where a defendant is able to demonstrate that the complaint falls within the purview of the anti-SLAPP statute, a plaintiff must demonstrate that the complaint is both legally sufficient and supported by a prima facie showing of facts to sustain a favorable judgment if the evidence submitted by plaintiff is credits? That I can't believe that's an accurate quote because it doesn't make sense. Demonstrate that the complaint is both legally sufficient and supported by a prima facie showing, initial showing, on its face showing, of the facts to sustain favorable judgment in the evidence submitted by the plaintiff is credits. That, okay, I can't. The burden of the plaintiff is low and only requires a showing of minimal merit. As one California court explained, precisely because the statute permits early intervention in lawsuits alleging unmeritorious claims of action and that implicit free speech concerns unmeritorious causes of action that implicate, whiskey, free speech concerns, and 2, limits the opportunity to conduct discovery, the plaintiff's burden of establishing the probability of prevailing is not high. So they've moved on to the second part saying, look, if you find that the defendant has met their first burden, we will meet our second burden. So kind of arguendo, if you find this, then that. Plaintiff is likely to prevail on its cause of action. This is just setting the standard. To prevail on a claim for intentional interference with economic relations. Defendant's sole defense to this cause of action is that plaintiff does not plead and cannot prove the elements of the cause of action. Defendants apparently ignored the fact where plaintiff alleges that Triller is a popular video sharing social network service app and has numerous existing economic relationships and business opportunities within the industry. That's not going to be sufficient. It's like business. Oh, business. Plaintiff is likely to prevail on its cause of action for intentional interference with prospective economic relationships. Again, defendant's sole defense is that plaintiff does not plead and cannot prove the elements. Once again, defendants appear to have ignored the fact where plaintiff alleges Triller is a popular video sharing app and has numerous that's just words. There's nothing else. Those are the barest of factual conclusions. Okay, you're not getting any more attention. Plaintiff's likely to prevail. You're going to just keep saying the same shit. Defendant's sole defense is that you don't, based on decades old case law. Look, just because it's old doesn't mean it's bad. That there's no cause of action for negligent interference with economic relations. This is curious to say the least in light of defendant's concurrent admission to the Court of Appeals last year endorsed such a cause of action and set forth the elements thereof. Because defendants admit that there is a cause of action, they don't admit. They argue that there's a cause of action. But it's like, because they say there's a cause of action, then we win. Plaintiff is likely to prevail because defendant's sole defense is that Triller's cause of action fails. Because the defense is meritless, there is a clear probability that Triller will prevail. You don't say, none of these words have meaning. You haven't said anything or proven anything. You just keep restating things. Okay. The court should award plaintiff its fees and costs in opposing the motion. Doubtful. But there is a chart. Let's go to the chart. There is a declaration with a chart. We're going to get to that. Is this the one with the chart? Yes, this is the one that's 200 pages long. Mods, don't have a heart attack. We're not going through all 200 pages. Just take a deep breath. That we will get to the response on Tuesday because there is a response from Ethan's legal team. But this is like, but we said that we can prevail, therefore we prevail. It just no. All right, let's get to this declaration of Brian Blatz in support of the opposition to defendant's motion. I'm Brian Blatz. I'm the attorney. All right, Blatzy, let's see how trillery this shit gets. Triller is a privately held company. Cool. Triller became aware of a inversion issue. Wait. Does Triller admit that it's flipped? Is that what's about to happen? Is that what's happening? This lawsuit's 30 times longer than the fight was. Yeah, and more entertaining, I would proffer. It's my opinion. Oh, I think Triller admits that it's flipped. Okay. On or about July 7th, 2021, Triller became aware of an inversion issue. Because I was inverted. They've gone with the Top Gun defense. Oh my God, I'm dying. I can't. I can't. Y'all. I looked at the chart that's coming up. I did not look at this. I was not prepared. I was not prepared. I was not prepared. It's not flipped. It's inverted. Okay, I got to start over. All right. July 7th, 2021, Triller became aware of an inversion issue relating to the app's camera function on certain iOS devices. On or about August 4th, Triller rectified the inversion issue, so almost a month, relating to the app's camera function. Accordingly, any individual who used the app on an Android device or on an iOS device on or after August 4th would necessarily not have been affected by any inversion issue relating to the app's camera function, but it was flipped. Their lawyer has admitted that it was flipped because it was inverted, aka flipped. How many 1-star reviews did it get during the month, almost a month, that their thing was flipped? Oh my God. I like that their lawyer admitted that it was flipped. Yo, Triller, your thing's inverted. I'm dying. Okay. Since July 2021, the app has received thousands of 1-star reviews, maybe because it was inverted for a month. Concerning Triller and Ryan Kavanaugh, see Exhibit A, a true and correct copy of a log of approximately 2,000 1-star reviews on the App Store. We already read the percentages of this in the declaration. The thousands of 1-star reviews parroting defendants' allegations have had substantial detrimental effect on the app. What is the detrimental effect? Have downloads gone down? Has in-store purchases gone down? Just because you say the words doesn't make them true. You keep saying detrimental effect, but you haven't said what detrimental effect. According to plaintiff's internal analysis of the damage caused by defendant's conduct, thousands of 1-star reviews parroting defendant's allegations have 1, depressed the overall rating of the app, and 2, depressed the conversion rate or the percentage of customers who choose to download the app after viewing it on the App Store. By how much? Prove it. And are you sure it's not because your thing was inverted for a month? Or because there was negative press regarding your CEO? Like, how do you attribute that specifically? Because there was also negative press regarding the CEO. But okay. Despite thoroughly reviewing Triller's records, I was unable to find any indication that defendant Ethan Klein ever created an account to use the app. So they're saying he never used it and reviewed it. He said he downloaded it. Doesn't mean he put it under his name. And I don't think you know his IMEI number. Each of the records discussed herein and attached hereto is an original or duplicate of an original. Let's see some of what Brian Blatz has attached. Look, there are 200 pages of this, and it is the reviews. Triller, my thing is flipped. App makes me want to break my new phone, makes me sick. Also, Ryan looks eerily similar to Harvey Weinstein. Hide your kids. Please stay away. The owner is running a Ponzi scheme and is suing everyone and is desperate for cash. Worst version of TikTok. I opened it twice before deleting it off my phone. The money they make off this app goes to suing YouTubers and paying the Trump family to incoherently ramble about boxing. Regret downloading it. I mean, how do you prove that person's an H3 fan? that could have just been from the news. Fake TikTok wannabe app. Also, TikTok and Triller were in a lawsuit. And I mean, fake TikTok wannabe app. It's boring and it's comprised of mostly re-uploaded TikToks. If you find something interesting from a reposted TikTok, you have to leave the app, go to TikTok, search the username, find the video you just watched, hunt for a follow-up. It's absolute trash. I would not recommend this app to my enemy. Waste of time, space on my phone, and resources. Imagine trying to make a knockoff app and putting money into it. How do you prove that that person is a fan of the H3 podcast? That is a legitimate criticism. The app is all re-uploaded TikToks and it's annoying. Okay. Trash app. Also, Ryan Kavanaugh was accused by his ex-partner of running a Ponzi scheme. Hard pass, fam. Again, that was a news article. How do you prove where they heard the news article from? How do you prove this to a jury? Just a complete TikTok ripoff, but without the entertainment. No one's on there. It's a dead app. Also, I heard the owner is accused by his ex-partner of running a Ponzi scheme, and I'm not about to support that kind of behavior. Somebody's going to be like, yeah, I heard he also sold LuLaRoe. It's a joke. It's a joke. Hey, Team Triller, whom do I contact if my app is flipped? I'm 100% serious. Papa bless y'all. Sorry. This is in a lawsuit. It's in a lawsuit. TikTok knockoff CEO was accused of running a Ponzi scheme. App makes me want to break my new phone. Is that the exact same? That Cav looks like Harvey Weinstein, but is this TikTok knockoff? The CEO was accused of running a Ponzi scheme, which is disgusting. Bro, just quit while you're not ahead. I mean, it's advice. The owner is running a Ponzi scheme, suing everyone, is desperate for cash. That sounds like the exact same review that's up above. And I wonder if it is. It's the exact same review. Look at that. Apple Guy Cobert from 9/16/2021. It's got a number 7810861853. Is the exact same. 782796060. I would imagine it's the exact same user leaving an app. Can users leave more than one app? Because this one's from 9/16 and this one's from 9/13. Can a user leave more than one app in the App Store? Because that is the exact same review by the exact same user on a different day. Upon opening, Mr. Kavanaugh appeared, causing me to have a seizure. I thought it was Harvey Weinstein. I mean, I was just chilling and then it just flipped. Your app is flipped. The app is flipped and wants to be TikTok so bad. The app is clearly a cheap knockoff of another short-form content platform. The few videos that manage to get uploaded here seem to be awkwardly assembled, almost as if the recording interface was inverted or even flipped. Couldn't imagine anyone using this app if they weren't being paid to do so. I mean, how are you going to prove where all of these are coming from? Garbage app created by a garbage human being. That might just be a personal opinion. I am dead because of this app. I am but a spirit roaming the plains of existence on the sole cause of Ryan Kavanaugh ripping off TikTok and allegedly running a Ponzi scheme. Yo Triller, my thing is flipped. Worst app I've ever used. Yo Triller, my shit's flipped. Again, how do you attribute all of that? Because they admit that it was inverted. This is the first time for me writing an app review seems to be flipped 1 star. I hope that the H3 podcast does a dramatic reading of the 200 pages. Look, so awkward. How do you say that so awkward is how do you say that how do you attribute that? Honest review only. Boiled eggs. Do they give a star rating? Nope. I wonder what the star rating is. They gave there's the rating. Those are 1s. Okay. So there's all the 1-star ratings. I downloaded the Triller app expecting technology unlike anything I'd seen to date. After all, this is Triller, a serious business we are talking about. Sadly, my thing's flipped. It's so awkward. 1-star app. This app ruined my life. I mean, seems flipped. They admitted it was flipped. So I don't know what they're going to do with all this. That's a lot. I apologize. I can't believe we've been on for 2 hours and 15 minutes. I'm sorry. There are hundreds of these, yay, thousands. This one's about Kevin Hart. Hold on. Hold on. Where did it go? There was one about Kevin Hart. Damn it. I saw it and I lost it. And I'm not going to control F it because I should get to questions. But there was one in here that as I was just going through about Kevin Hart. This one says, I sense a lawsuit incoming from TikTok as this is a direct ripoff, except 10 times worse. Okay, this one, maybe. This one says Foot Soldiers Unite. Maybe that one. Maybe that one. I mean, sure. They're alleging brigading. Okay. People are allowed to leave reviews on the App Store. We'll see. It'll be interesting to see if they prove damages or if this is fair use. I think it's fair use. They said leave an honest review. They're admitting in their lawsuit that the thing is flipped. Should I share that on social? Should I clip down that part and be like, Triller admits their thing is flipped? Do we need to change the title of this video to Triller admits this thing is flipped? Okay. A huge thank you to the mods. I'm going to get to really quick questions, and then we have a few things we need to do for court of public opinion because it's spooky season and we have things. Questions. I have questions. You have questions. I'm going to try. If I don't get to all of the super chats, I apologize. I'm going to try, but I legitimately do want to get to questions. You guys, this thing is just... Look, Sydney said it. Ethan didn't tell people to leave bad reviews, though he said leave an honest 1 or more star review. He did. And the lawsuit would be better taken by me if they focused on that and didn't focus on all of the personal name calling that went back and forth on Reddit. Again, you have to focus on the strong bits. I think that throwing in everything else diminishes the strength of the suit. We'll see what happens on the anti-slap motion. You know how I feel about it all. So I think that this is petty. And I think that they are trying to silence Ethan. I think that they are saying, oh, Ethan's bullying us by leaving all these 1-star reviews. He didn't do it. He left 1. You know, you have an app that has had issues. You have people that are paid to use your app that have talked about those issues. You have people commenting on that online, which is literally the internet, and you're mad at the internet. Okay, Triller, be mad at the internet. Be mad at the internet. Be mad at the internet, Ryan Kavanaugh. Sure. Honest question. Did you know my birthday was yesterday? I did not. Happy birthday, Haunted Shadows and Legacy. Knowledge and Beauty said, question, can the officials like the pathologist who declared the death in the hit and run and the cops who tried to suggest that another person was driving the boat get in trouble for covering the Murdaughs? I will get into that more, but there is now a lawsuit into the alleged conspiracy with regard to the boat crash. I haven't gotten into the other hit and run, but yes, that can happen. So yes, that can happen. This is the house of cards with the Murdaugh family and whatever else was going on is crumbling down. So it is going to be bad. Is this lawsuit involving 1-star reviews the first of its kind? I don't know. I haven't looked. I don't know. It's really a brigading lawsuit, isn't it? I have not looked, but I will. I don't even know how I would look for that, but I will do some research and I will ask around LawTube and see if they've come across anything. It is very, very interesting, for sure. So, question, do you think H3 will watch this and laugh with us? I hope so. And probably, because occasionally I'll get a DM after one of my videos. Because you know what? Some lawsuits we take more seriously than others. This will be very interesting. Either way, it will be very interesting. Missy said, I love candy. I still love candy corn no matter what your poll said. Look, the poll, COPO, Court of Public Opinion. Court of Public Opinion did not say, you have to stop liking it. It's just a general cross-section of what is the public opinion of the thing. And I think most of us candy corn lovers knew going in. that, the majority of people hate candy corn. But it doesn't mean we can't like it. It just means the broader public opinion is bleh. But that doesn't change our opinion. What I love about court of public opinion, it's a way to have fun agreements or disagreements with regard to particular topics. And that really is a fun part of it. So we will get to that in just a second. I'm going to get to just a few more questions. Oh, let me go look for a few of the super chats I missed because I always appreciate them. And I try to balance getting questions from super chats and not from super chats to make sure that you don't have to be a member. You don't have to super chat the channel to still get to participate, ask questions, and just, laugh along with the rest of us. And that is always the goal. And that's why we have such amazing and dedicated mods so that we can do that. And I can try to get to everything. It's also why there's rules like no all caps. Nightbot gets salty, but it's like why there's rules like that too, because it helps me be able to see different things. Oh, Sandy brought up something too. COPO shows a nice cross section of people. It does, but it also reminds us, particularly those of us in the US, that there are, we have broad differences, not just regionally, but geographically within the US and then internationally too. I didn't know truly that candy corn was a US specific candy. I had no idea. So court of public opinion taught me something, as it always does. And we've come across that with other things too, with the amount of our lovely worldwide law nerds that have said things like, what is ranch dressing? And I was like, wait, what? Yes. So when you come visit the US, you have to try ranch dressing. I'm just letting my mods know. Tech, you don't have to put them in there. I pulled them up back end, so I'm going to grab them from the back. Thank you so much. I didn't want you to have to hustle. So Tara XOXO said Triller is a mess. It's inverted, apparently. Cindy Thomas said monetization is nothing. You have the law nerds backing you. Thank you, law nerds. R.R. Smith said, can they claim if you've been demonetized? I didn't have anything that I streamed today, so no. But even if you have been demonetized, yes, they can. Jennifer H said, what do you think lawyers equals more likely? Why do you think lawyers equals more likely opioid problems? Oh, I think lawyers don't take very good care of themselves. Other professions might have this issue too, but I am familiar with mine. And in California, when you do continuing legal education, you have to do addiction specific education too. So with lawyers, I think there's a lack of self-care. I think there are long work hours, high stress, high stakes. I think you see lawyers who are, I've seen lawyers who are in the hospital after just giving birth back on their laptops trying to answer emails, not giving people proper time to heal after injury and accident, particularly if you're not taking good care of yourself as you get older. And then I think a lot of lawyers are deeply unhappy in their work environment and their work situation because of the lack of control of their own lives and the high stress and the high pressure. So I think that it's kind of a clusterfuck of a profession at the moment. And it is very hard, the drive towards being a prestigious lawyer or someone who's like looked upon in this society of lawyers is like moving to big law, doing this kind of law, rising up the ranks. Like there's a stratification of type of law. And we see it with the way other lawyers talk about me at times, not LawTube lawyers. Because LawTube gets it. LawTube's like, living my best, boo. We having fun doing what we're doing. But more traditional lawyers who are like, why would you ever do that? Like, you're supposed to want these things. And it's like, no, I don't. Why? Why would I want to be sick and stressed all the time? No, thanks. But there's a lot of internal pressure within the profession. And I think that that's hard. So, yep. Moody says, if the judge keeps dismissing without prejudice and Triller keeps suing, can H3 sue for harassment? At some point it will come up, like vexatious litigation. But if a anti-slap is granted, then the anti-slap just ends it because it's granted with prejudice. Call Me Al said this is the polar opposite of the thirst trap law. It is. Sandy said for pull-ups for Steven. Steven might need it. He might need a cushy tushy pillow, maybe, or like one of the sleep number beds. I have one because I'm an old person, but one of the sleep number beds where you can like sit up, but you're still laying down just to take the pressure off. I got one when I had my spinal fusion. It was great. Not inexpensive, but it was great. It's very heavy to move. Lynn said, let's be glad he didn't provide proof. Oh, and we got to those. So I think we got to a lot of these. Thank you guys for that. Annie said, have you considered running for district judge? No, because I did not apply for comedy or for my license to transfer here to Tennessee. So no, I would probably teach and work with law students before I would run for judge. I would not be a good judge. I would be like, you're making my thing flipped right now and I can't. Like after doing this, I couldn't. I love this. Teresa Minnesota said, would a female lawyer ever put the personal life craziness in a filing? Unlikely in my experience. Jesse said, that's such a man thing to say. I had to take on other duties. PSA, men, don't say this ever, even if your wife might end you for it. Yeah, your wife might end you for it. Allie said, first live, love your shirt. Thank you, Allie. I love my Weezer shirt. It's got a unicorn Pegasus on it. It's amazing. And it says rock music. I love it. I mean, I often wear the Law Nerd merch, but I was already in the Weezer shirt working today and it felt good. So we left it on for sure. Taz said, hi from Ireland. We got that one. Thank you, Taz. Plastic Noise said, Crime Talk covers Murdaugh a lot. You should have him on sometime. I will go look for it. This was the Murdaugh situation is a new one for me. So it was like let's get into it. And it is a lot. Samantha, thanks for the super chat to help you heal from the trauma of seeing that lawyer's butt. And Kissy Kissy said, I always pay for my booty pics. I mean, if you pay for your booty pics, they're probably going to look better than that one. I'm just saying. So thank you all for the super chats. Thank you all for the support. Let us get to a little bit of what we're talking about for COPO. We talked about this last night on the members only live stream. We are going to do another bracket. If you guys remember the last bracket we did, it became extensive very quickly. The last bracket we did was over the worst influencer apology video. This bracket is going to be over, and let me pull up the chat so I can enter these in so I don't have to, so Tech doesn't have to do it also because I want to. So give me one sec. Let me pull up the chat without hearing myself. Thank you, self. We are going to do some polling because we are going to run off 12 movies. Well, I'll tell you what. Let's get into COPO. So we're putting up a few rapid fire polls, so keep your eyes out for them because we're going to ask quickly. I'm going to type them. Typos are courtesy of me. So is spilling water on my desk when I'm talking with my hands like this. So with COPO, we are going to do a poll or a bracket of best Halloween movies. We're going to try. Look, we are going to do best franchises after this. So we are picking one movie, not entire franchises. When I asked the members, we got quite a long list of movies. We're only going to do 12. So I have a few questions as to if it is or is not a Halloween movie, so we can narrow down to 12. There are a few essentials that I am just ruling must be included. So we're going to poll some of the ones that I'm like, is it a Halloween movie? First poll that's up is Nightmare Before Christmas. Halloween movie? Christmas movie. Halloween movie? Christmas movie. Like it's a vibe. It is Disney transforms the Haunted Mansion in October. So what do we think? So that poll is up to see if it makes it onto the list. The things that are on the list automatically are Hocus Pocus, Halloween, Scream, Nightmare on Elm Street, Friday the 13th, Beetlejuice, Young Frankenstein. What else? Rocky Horror Picture Show, because yes, Practical Magic. Yes. It's the Great Pumpkin, Charlie Brown, because yes. What else? Addams Family. That's not 12. Death Becomes Her, I'm going to ask you about next in the poll. So we're going to go ahead and close this poll. You guys said yes. You guys were like, yes. All right. Nightmare Before Christmas and Nightmare on Elm Street. That'll be interesting. So Nightmare Before Christmas makes the list. Let's see. Death Becomes Her is the next one. So I'm going to pull it. Because we're only doing 12. We might have to do 2. We're only doing 12. So Death Becomes Her. Is Death Becomes Her? Oh yeah, Halloween Town. We have to do Halloween Town. Sorry, you guys are like, Halloween Town. I'm like, yes, I don't know why I don't have it on here. So what we have on here, let me make sure as I'm working on my list, we're pulling Death Becomes Her. We have Scream, Halloween, Hocus Pocus, Rocky Horror, Practical Magic, Nightmare Before Christmas, It's the Great Pumpkin, Charlie Brown, Friday the 13th, Addams Family, Young Frankenstein. Oh crap, Beetlejuice, Nightmare on Elm Street, and Halloween Town. That's way more than 12. We're going to end up with 16 in this bracket. Damn it. But do we think Death Becomes Her is really a Halloween movie? Y'all are saying no. All right, it's coming off the list. That's helpful. We've got to whittle down this list, y'all. We've also got under consideration Edward Scissorhands. Edward Scissorhands, yes or no? So let me end this poll. I love this fast polling. It makes me feel like I'm running my own, like, Watch What Happens Live. So that's what I'm living for. Tech, will you end that poll so I can add this one? It didn't end for me. Let's see. Maybe it ended for me now. Thank you. It won't let me add a new one. Why? Why can't I add a new poll? There we go. What was I pulling? I was pulling Edward Scissorhands. I think Edward Scissorhands is Christmas too, but why can't I spell scissor? So, and we're also not leaning heavily into the gore category, but Edward Scissorhands. Oh, Sleepy Hollow is a fantastic movie. Darn it, it's not on here either. We might end up with a 16. We might end up with a 16 movie bracket. Because The Shining. But The Shining feels more general horror. But The Craft should probably be on here too, right? I think we're gonna end up with 16. My poll is flipped. But yes, everybody's like, no, Edward Scissorhands Christmas. Okay, that's super helpful. We need to get some out of here. We can't have all of them. Edward Scissorhands is a no. Perfect. Let's end that poll and take it off the list. You guys are the best. All right. Oh, Fred is done with this. So we've got Scream, Halloween, Hocus Pocus, Rocky Horror, Practical Magic, Nightmare Before Christmas, The Craft, It's a Great Pumpkin, Charlie Brown, Friday the 13th, Addams Family. That's 10. Young Frankenstein, Beetlejuice, Nightmare on Elm Street, Halloween Town, Sleepy Hollow. We need one more. Does The Omen count as the one more, or The Burbs? Or Corpse Bride? Damn it. We need one more. Okay, I'm going to pull The Omen, The Omen, Corpse Bride, and what else did I say? And The Shining. Those three. Let's just pull those 3. Which one? Oh, you guys are like Carrie. Okay, Carrie, The Omen, add an option. Corpse Bride. This is why we do COPO, so we can actually put together these polls. I had one more. Oh, and The Shining. Oh, what about The Burbs? Damn it. There are so many good movies. But we are doing the Law Nerds version. All right, there we go. We've got 4. Yes, it's the original Halloween. So for the original Halloween, I'm putting up the original Halloween and the original Nightmare on Elm Street. So, and I will interchange it with Friday the 13th. Oh, Hocus Pocus is already on there. I don't know if we could do 20. Oh, Jennifer's Body is good too. Oh, The Exorcist is good too. The Exorcist just feels like horror for me. I don't know if it feels like Halloween specific for me. You know, if that makes sense. Does that make sense? So we're going to pull this, and then no, Hocus Pocus is already on the list. Hocus Pocus and Practical Magic and The Craft are already on the list. So the list already includes the ones that I named. We're just trying to round out the list. So we are trying to finish up the pack here, and we will see what makes it onto the list because we have to have an even number. There are too many great films. We are going to do franchises. So don't worry, we're going to run down best scary movie franchises later. These are like Halloween movies because we'll get to scary movie franchises, and we're going to do the Halloween franchise, the Friday the 13th franchise, the Scream franchise, and others. So we're going to do like scary movie franchises, and then we might have to do gore movie franchises. So this is going to be a poll. And then like we did with the influencer apologies, I will put up the brackets on social media. You all can fill out your own brackets, and then we will run them off against each other in a series of COPO polls. Let's see. I'm going to go ahead, Tech, and let you end this one because we're at over 2.5 hours, and I, A, am tired, and B, have to go to the bathroom. It's time, and I want to eat. Because I don't always eat before we didn't do Frankenweenie either. Damn it. Loved The Craft, brings back 90 memories. Look, I'm a 90s bitch. Like it is, it just is. It is. Oh, we didn't even get to the birds. Yes, we will do a gore franchise because like Saw is not going to go running off against Scream. Saw is for sure gore, and gore is fine. Oh, Ghostbusters. It's not, I don't know if we have room. Do we have room? Let's end this list. I'm going to go ahead and end this poll and see what wins. And then we will go from there. Okay, so out of that group, let's see what won. Out of that group, Corpse Bride smashed it. All right, so Corpse Bride is in, and I think Ghostbusters might have to be in. And then will we have an even number? Let me see. We have 16 right now. So if we add Ghostbusters, do we add Ghostbusters? Blair Witch, Pet Sematary. We might have to add Casper. I love that we get 2 because we do have okay, Casper. Beetlejuice is already in. Yes. All right. I see lots of Casper. High Spirits and Paranorman. We're going to have 18 in this. We should just do a Tim Burton bracket. Oh my goodness. Okay, we're going to go with 18. We're going to add Casper, and I said one other one. What else did I say? We were adding Casper and we were adding Ghostbusters. All right. Casper, Ghostbusters. So here's the list so far, and we're going to bracket them by random selection. Scream, Halloween, Hocus Pocus, Rocky Horror, Practical Magic, Nightmare Before Christmas, The Craft, It's a Great Pumpkin, Charlie Brown, Corpse Bride, Friday the 13th, but I'll put in the actual title of the first one. Addams Family, Young Frankenstein, Beetlejuice, Nightmare on Elm Street. Wait, Nightmare on Elm Street and Friday the 13th are the same, right? Right. Halloween Town, Sleepy Hollow, Casper, Ghostbusters. So I need one more because I had a double. No, this is just the whole list. We're going to run them off against each other. Casper and Beetlejuice are both on the list. The Mummy does not strike me as Halloween-y, but Frankenweenie maybe does. So E.T. also doesn't strike me as Halloween-y. You guys are like, Coco, but Coco doesn't feel like Halloween either. Coco is like Dia de los Muertos, right? No, they are separate. You guys are like, no, leave it in. One is Jason, one is Freddy. See? I'm leaving it. We're leaving it at 18. We're leaving it. We've got to have all of them. All right. Friday the 13th, Nightmare on Elm Street. And those are going to be the original movies in the franchises because, yes. All right. That's why we started it with the members so that we would have some semblance of a poll. Some movies are going to be left out. Yes. But yes, I know Dia de los Muertos happens on Halloween. But we have lots of nostalgic movies. But we have 18. And Coco did not come up a lot in any of the things. Neither did Frankenweenie, which makes me sad. So we're going to run these off and we'll see what people say. I know The Burbs is also great. And The Lost Boys is also great. There are lots of great movies. They're not all going to make it onto the list. But this is going to be a hard. The Addams Family is on the list for sure. So we are going to bracket these. I will put the brackets up on social media tomorrow and we will start running them off against each other. I appreciate you guys. There are so many. Oh, you guys are like, no, Dia de los Muertos is November 1st. Well, thank you. See, I thought it was on Halloween. So now we know. But we will be doing franchises. We will be doing both, I think, scary movies and gore, but we are going to try to keep COPO in the spooky realm without just asking about food the entire time. You guys are like, what about Chucky? We can't do them all. We can't do them all. Lost Boys, we also can't do. Lost Boys didn't get a lot of love from the members, which is where the bracket started. Beetlejuice did, The Craft did, Rocky Horror did. And that's just what it is. So thank you guys for a great night. Thank you for hanging in here. We've got a nice mix of like family movies, fun movies, scary movies, classic movies. I appreciate animated movies. Not super gory movies because, you know, this is just. All right. So we will get it up on social. If you're not following me on social, at the Emily D. Baker. If you haven't liked the stream, like the stream. It's been a long one. A huge thank you to the mods. Thank you, mods. Thank you, mods. Thank you, mods. And I will talk to you guys on Tuesday, and we will do some case updates, and we will do the response to these Triller motions from Ethan Klein. We're going to do like a part 2. So stay tuned for that. And I will see you on Tuesday for Coffee and Cursey Words, and I'll see you around the internet over the weekend and on Monday. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just text Emily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.